The Appellate Division First Department is now in session. Good afternoon. Welcome to the Appellate Division First Department's virtual argument session. I'm going to begin by calling the calendar. As I do, please state your name and the party you represent, and I will confirm your argument time. First case is People versus Mark Bradford.
Elizabeth Hayden for the appellant.
Carl Kaplan for the appellant.
Good afternoon,
5-2 for the appellant. For the respondent?
John Croys for the respondent, Your Honor.
Thank you. 5 minutes. Korn versus Korn for the appellant.
Korn.
Korn versus Korn.
Korn versus Korn.
For the appellant on Korn versus Korn.
Korn.
Mr. Harper, you have your mic off.
Mic off.
Mr. Harper.
Harper.
Is Mr. Harper on the line? I can only see part of your face, so I don't know if you're speaking. I'll come back to Korn. T. Children is submitted. Sotakos versus TSC Group for the appellant.
Appellant, yes. Carla Variale Barker for appellant.
4-1 for the respondent.
Alex Walwick for the plaintiff respondent.
4 minutes. Aquero versus Nelson for the appellant. Aquero versus Nelson for the appellant. Okay, we'll come back.
Jim Bedura on behalf of MBIC. I'm sorry, Your Honor.
Okay, it's all right. That's 4-1, Mr. Bedura.
Thank you.
For the respondent.
Good afternoon, Your Honor. H. Jonathan Rubenstein of the Fine Silver Law Group PC, Appellate Counsel of the Office of Beth Schlossman.
4 minutes. Thank you. People versus Bobby Rock for the appellant.
Good afternoon. Anjali Pathmanathan on behalf of Mr. Rock.
4-1 for the respondent.
Jillian Lewis for the people respondent.
Four minutes. Thank you.
Thank you.
Mendler versus Jane Horatio for the appellant.
Good afternoon, Your Honor. Andrew Akron on behalf of the appellant.
And it's, oh, sorry.
6-2 for the respondent.
Yes, it's Stephen Younger for Jane Horatio LLC and Suzanne Lawton individually.
And 6-2.
Gerard Reese.
Oh, I'm sorry.
Yes, and Gerard Reese for the cross appellant. Good afternoon.
Thank you.
Yeah, I think we're doing 6 minutes for the opposition, and Mr. Riso is doing 2 minutes for the cross appeal.
Okay.
Thank you, Your Honor.
Thank you. Just checking back, is Mr. Harper here?
Yes, Judge, I am. This is Robert
Okay.
Harper for the appellant.
Korn
My
versus,
apologies.
just a minute, call it again. Korn versus Korn.
Korn versus Korn.
Good afternoon, Your Honor. Robert Harper for the appellant. 4 minutes, one judge. My apologies for the technical.
It's okay, 4-1, but I still have a lot of feedback when I'm speaking. And for the respondent?
David Casico for respondent.
4 minutes. Thank you.
4 minutes. Thank you.
Neary versus New York City Transit Authority for the appellant,
Tim O'Shaughnessy for transit, the appellant.
2 minutes, and the respondent is a submission. Eros International versus Mangrove Partners. We have 2 appeals. On the first appeal for the appellant,
Scott McLagan for the appellant, Your Honor.
4 and 1 for the respondent.
Chad Albert for the respondent.
Four minutes. On the second appeal of Eros International for the appellant,
Chad Albert, again for the appellant.
that's 6 and 2. For the respondent,
Good afternoon, Your Honor. Joseph Sorkin from Making Gump on behalf of the Mangrove respondents.
that's 8 minutes. People versus Talbot Smith is submitted. One West Bank versus Fox for the appellant,
Good afternoon, Your Honor. Greg Verrilli for the appellant.
4 minutes, 4 and 1, actually. For the appellant, the respondent, I'm sorry.
Yes, R. David Marquez of the law firm R. David Marquez, PC, for respondent Cassandra Fox, 4 minutes.
4 minutes. Lopez versus the City of New York is submitted. Harris versus Israel for the appellant. Harris versus Israel.
For the respondent, Your Honor, I'm present. Stephen Sperber, SDK Heiberger. For the respondent, Woodrina Israel.
5 minutes. I'm still waiting for the appellant on Harris versus Israel. Okay, I'll come back. Medina versus Shea for the appellant.
Michael Confusione, Your Honor, for the appellant, Adriana Medina.
5 minutes. For the respondent,
Susan Paulson on behalf of the city respondent, Your Honor.
5 minutes. Thank you.
Thank you.
Kotler versus 979 Corporation for the appellant.
Scott Mullen for appellant.
I'm sorry, Mr. Mullen, you didn't tell me who you're representing. I cut you off, sorry.
That's okay, appellant.
Good afternoon, Your Honor.
Good afternoon. 6 and 2, and for the respondent?
David Berkey, Gallet, Dreyer, and Berkey for respondent cross appellant.
And that's 6 and 2 as well. Thank you.
Thank you.
Tisla versus Biggs.
Good afternoon, Your Honor. For the city appellant, Diana Lawless.
3 and 1, Ms. Lawless.
And for the plaintiff respondent, Pedro Sosa, I am Diane Bando.
That's 5 minutes.
Good afternoon,
Good afternoon,
Your
Irina
Honor.
Kravchenko for the.
Sorry, go ahead.
Irina Kravchenko for the appellant Cabrera, Your Honor.
3 and 1.
Thank you.
Alina Vengro for defendants appellants Linda Greenhouse and Linda Suarez.
I'm sorry, can you give me your appearance again?
Sure. My name is Alina Vengrove, and I'm here for defendants appellants Linda Greenhouse and Linda Suarez.
3 minutes.
Thank you. And
Go ahead.
Appellants, I think there's one more appellant, isn't there?
Sylvia Soto from the law offices of Tremello and Fishman for defendant appellant Ulysse Cabral.
3 and 1.
Good afternoon, Your Honor. Chris Delacarpini for respondent, Mr. Sosa as well.
That was the respondent, 5 minutes.
Thank you.
Did I get every? Okay.
I'm sorry, Diane Bando, once again, for plaintiff respondent Pedro Sosa. He's a respondent on both appeals.
Okay.
Your Honor, Alex Imke, appearing for petitioner Matthew Harris in Harris v. Israel.
I'm sorry, Your Honor, is my 5 minutes for both appeals?
That's on both. That's a total. Yep.
Okay.
And for Harris versus, I'm sorry, for the last person who spoke, Mr. Bander. Can you repeat your appearance, the last person? Sorry.
Your Honor, Alex Imke appearing for Matthew Harris in Harris v. Israel.
If you would just wait until I get back to that case, please.
I deeply apologize.
Is there anyone else on Disla versus Biggs? Okay. Thank you. So that was 3-1 for Ms. Lawless, for Ms. Krachanka, 3-1 for Ms. I won't get the name right, but for the attorney for Suarez and Greenhouse, 3 minutes. The attorney Sylvia Soto is 3-1, and for both respondents, that's 5 minutes total, 5 minutes each. Disla versus, I'm sorry, Jarek Associates versus Phoenix Owners is submitted. Now back to Harris versus Israel for the appellant, please.
Good afternoon, Your Honor. Alex Imke appearing for Matthew Harris.
5-2, and Mr. Sperber, I had already given you your time. It's 5 minutes. Okay, attorneys, please remember, as always, that we have your briefs, we have your record, we are fully familiar with the facts of your case, so please go directly to the most important points you wish to make. Also, as is customary, please don't speak over the justice or over one another, because especially during our virtual arguments, it's important to hear the questions that are asked. And finally, keep your mutes, I'm sorry, it's not a good day. Keep your mics muted until you begin your argument so that we don't have a lot of the distractions. And try to remember to unmute them when you begin. Thank you for your patience and your cooperation. The first case we have is People versus Mark Bradford. Ms. Hayden?
Yes. Am I ready to go?
You may begin.
Thank you. Good afternoon, Your Honors. I'm Elizabeth Hayden, an extern at the Center for Appellate Litigation and a recent law graduate for appellant Mr. Bradford. The court erred in its justification instruction in this case because it failed to inform the jury that if Mr. Bradford was in his dwelling when he was confronted with the imminent use of deadly physical force, he had no...
Counsel, it was Mr. Bradford in his dwelling. Wasn't he in the lobby? And hasn't the Court of Appeals ruled that being in the lobby is not a dwelling with respect to whether or not one has to retreat in these circumstances?
Your Honor, those cases mostly address an apartment situation. This was a very unique living situation at a men's shelter. And I'm arguing here—
It's a men's shelter, but similar to an apartment in that the rooms are upstairs and there's a lobby and one has to take an elevator or some other means to get up to where the rooms are. So isn't it similar to those cases still?
It's important to really consider the layout here. In order to get to that lobby, one has to pass through a significant number of security measures just to ensure that members of the general public are not allowed into those private spaces.
How would that differ from, let's say, a doorman or a concierge or something?
Well, the main difference here between a lobby and this situation is that Mr. Bradford's home in the shelter was spread out throughout. Upstairs in his dorm room, where the people are arguing is his dwelling, is basically where he slept. He had a bed and a small locker in there and really nothing else. The downstairs area where this incident happened, that's where the majority of these residents, these residents spent the majority of their time. There was a communal kitchen, recreation area, dining room, and that was Mr. Bradford's dwelling. In fact, when this incident happened, the complainant was playing dominoes in that recreation room.
This is Judge Ong. I don't mean to interrupt you, but to me, one of the questions I have to ask is, an expectation of privacy, because when you're in your dwelling, you have an expectation of privacy. That's your place. It's your sacred place. It's your sort of, place where you can just sort of unwind. How is that in the lobby? Is there any expectation of privacy?
Well, Mr. Bradford didn't have any greater expectation of privacy in his dorm than he did in the lobby or in the recreation area downstairs. Up in his dorm, he had a bed. He didn't even have a partition for privacy. He couldn't lock the door. The locks and security measures on the shelter were really his sanctuary from the outside world, which is the purpose of the rule, that someone should have a place for sanctuary and shelter. And that was the entire interior portion of the shelter for Mr. Bradford. And the fact that he had over 100 housemates doesn't make this any different than living in a shared home with 5 other housemates and having a hallway that takes you from your bedroom to the kitchen. Only here he didn't even have a
if you take it to the logical conclusion that you're saying that he had no expectation of privacy even in his room, then the whole place is not a dwelling, because anybody can move about and there's no privacy at all. I mean, the rooms are not locked, everything is open. So there is no dwelling so there is no exact dwelling, quote unquote, defined anymore in this place. It's just an open space. It's almost as if you're like staying in a sort of a large arena or something, correct? I mean, that's the logical conclusion of what you're saying.
That's a bit of a mischaracterization of the shelter setting. In order to get to that private area of the shelter, one had to be let in and be allowed to be there. So there was an expectation of privacy, and that no person just off the street was going to walk in there. He knew that once you'd passed the security office, past the metal detectors, he was in his home, and that's where he was safe from the outside world, which again is the entire purpose of the rule here. And really important to consider is that if the lower court's ruling stands, people like Mr. Bradford, who can't afford the luxury of their own private home, effectively don't have a place that's a dwelling. And if they're confronted by bullies, they will always have to retreat. And if you look at the Hernandez case.
Well, I mean, let's just, sorry, a different aspect of this is, you just mentioned the security and everything. I understand we're talking about the duty to retreat, but the security and everything was just steps away, I imagine, from the elevator. And there are videos that show I don't want to get into the other facts, but we might as well go there. There's video evidence that the defendant was stopping the elevator from going and was somewhat of the aggressor, at least from what we can see from the video, so that he chose to engage instead of going and getting the security guard, which would have been on that very floor.
Well, here, when Mr. Bradford was confronted with Mr. Ewing in the elevator, actually both men testified that the first physical thing that happened was that Mr. Ewing pushed Mr. Gregory out of the way, clearing a path between him and Mr. Bradford, which Mr. Bradford interpreted as a challenge to imminently start fighting him. And he knew that these men were violent and that they were very capable of pulling him into the elevator and exerting deadly physical force, because just 2 weeks prior, Mr. Bradford had seen the complainant do exactly that against another roommate based on a similar type of roommate disagreement. So it was reasonable for him to assume that something like that might happen in the midst of this fight.
Okay, thank you. You have rebuttal. For the respondent, Mr. Croyce, I think.
Yes, Your Honors. Jonathan Croyce for the people. May it please the court. To begin with the stabbing itself, as Your Honors pointed out, the videotape is pretty crystal clear on this. The initial aggressor, the only individual to use a deadly weapon in this confrontation, was the defendant.
Well, we only know that he's the initial aggressor from what we see. I mean, there's a difference of opinion as far as the facts here, but from what we see, yes.
Well,
from
Your
what we
Honor,
see in the video.
Certainly on the video, but Your Honor, I would also point you to defendant's own testimony.
I know what the testimony says. I know it was a jury trial. I understand.
Absolutely, Your Honor. So defendant cornered these two men in an elevator. As he admitted on his testimony, he could have stepped back one step and let the elevator doors close. He didn't. Instead, he lunged at an unarmed man with a knife. The two men that he claimed to be afraid of, they were retreating. They were heading upstairs. He was not allowed to use deadly force in that circumstance. But to go back to, I think, the more interesting question, the dwelling question, Your Honors, based on the Court of Appeals precedent that we have, Hernandez and Aiken, this was not a dwelling. This is essentially akin to the lobby, stairwell, the registration area.
So what about counsel's argument that in the lobby here, it's recreation? It's the only place these people who don't have privacy upstairs, but simply have a bed in an open area, I think with 8 people to a room, that this is their living space. This is part of their dwelling. What about that argument?
I don't think so, Your Honor. Let me tell you why. This is not a case, first of all, and I'd push back against my opponent's characterization of this as needing to decide the entire question of where a dwelling begins and ends in a shelter. I think this is a relatively narrow question. Defendant wasn't in the rec room. Defendant wasn't in the common area. Defendant was in the hallway that connects the entrance of the building to the security offices and to the stairwells and to the elevators. So even if we accept the defendant's formulation, and again, Your Honors, I don't think this court needs to go there to answer this question, he was still in a part of the shelter that is essentially the lobby area from Hernandez, the stairwell from Hernandez. He was in a public thoroughfare, a semi-public thoroughfare for everyone in that shelter. And the area that seems most naturally his dwelling is his rooms upstairs. His rooms upstairs had a door. They were limited to the individuals that stayed inside them. It's where he kept his things. And if you look to the reasoning in Hernandez and Aiken, to go back to something else that my opponent said, you can clearly see that the Court of Appeals has rejected an analysis based on the physical security setups at issue. They explained pretty clearly in Hernandez that there's an economic justice issue here, where if you base your decision on what a dwelling is purely on how well somebody's security is set up, well, then you've allowed the rich to build dwellings and the poor not to. I mean, the Court of Appeals said this explicitly in Hernandez. So they were looking more towards questions of exclusive expectations of control, expectations of privacy, and frankly, Your Honors, to the more emotive question of what is one's home. And they've drawn that line relatively narrowly, given that people's lives are at issue. And I think when it comes to an elevator, a hallway, in a shelter, that is not a dwelling. That's not where he slept.
Thank you.
Not where he rested. And if Your Honors have any further questions about that or about the stabbing angle itself, I'm happy to answer. Otherwise, we'll rest on our briefs.
Thank you, Ms. Hayden.
Thank you.
Thank you, Your Honor. So the dorms here were not limited to the individuals who lived there. I think that's important to consider. Any member of the shelter could be in anyone's room. They were not locked. They were not allowed to lock them. And the hallway was not public or semi-public. Members of the general public were not allowed inside. You had to have a reason to be there, and you had to be vetted by someone at the security office to get inside. And in terms of it being a hallway, inside anyone's apartment, there's going to be a hallway that connects.
How is that any different than a lobby in a building, though? Let's say you have to go through security to get into the lobby of the building, and everyone who lives in the building can be in the lobby. Isn't that the same as the situation you're describing, where everyone who lives there can be in that area, but the general public cannot?
Anyone who lives there, it's more akin to a shared home here. But members of the general public, they can walk through the front door, but they can't get into this interior area of the shelter. And if you contrast this with Hernandez involved people with private apartments that had locks that they could go to. This is very different. The lock that Mr. Bradford could use was that security that kept people out. And it is true that Hernandez says that the level of security shouldn't matter because it specifically stands for the idea that people who don't have enough money to live in a place with robust security should still benefit from the rule. And that's exactly the case here. The fact that there's security merely shows that members of the public were not allowed inside. If one walked in there, it would clearly signal to them that they weren't allowed into those private areas. And lastly, just to address the initial aggressor, it is true that Mr. Bradford was the one to use a weapon, but Mr. Ewing didn't need a weapon here to be the initial aggressor. He's shown in the past multiple times that his fist.
This is true, but this was a jury trial and the jury considered the credibility of both, and we have to defer to the jury's credibility findings in this instance. Thank you both. Ms. Hayden, you are a law graduate of Columbia, now working. And waiting for bar results, I imagine. So that to be admitted. So I wish you the best. Excellent argument. Excellent for both of you. Thank you very much.
Yeah.
Thank you.
Yep. Korn versus Korn.
Good afternoon, Your Honor. May I proceed?
Yes, this is Mr. Harper.
Yes, Judge, it is. May it please the court. My name is Robert Harper, and I represent appellant Robert Korn. Robert respectfully requests that this court reverse the surrogate's order dated January 9th of 2020, which dismissed his petition to allocate to respondent Edward Korn, individually or as executor of the estate of Edith Korn, the legal fees that Robert incurred in prosecuting objections to Edward's counting.
Mr. Harper, did the money that was recouped go to the estate, or did it go inure to the benefit of Mr. Harper? Didn't it, half of it go to to Robert? I'm sorry.
Yes, Judge. So
Robert, as opposed to the other brother?
With respect to the post-trial decision, while the premium on the Florida Flats property of $2.4 million and $250,000 for the advance will ultimately inure to the benefit of Robert Korn, the surrogate allocated to these two those premium proceeds as well as the advance payment. And in that respect, there was a benefit, a financial benefit to the estate that justified shifting to the estate the legal fees that Mr. Korn incurred in prosecuting these objections. Now, that is not the only financial component.
Tell you, what was the benefit to the estate separate and apart from the benefit to your client? I wasn't following what you said.
Your Honor, with respect to the Florida Flats premium proceeds of $2.4 million and to the $250,000 advance, one half of that amount was allocated to the estate. It ultimately will be payable to Robert Korn, but it was allocated to the estate.
But if it's ultimately payable to him, why isn't it just a benefit to him? And then why should he get attorney's fees if it's ultimately going to be allocated?
Your Honor,
and before you answer that, I'm just going to remind all attorneys, please, if you're not the attorney who's speaking, please mute your mics. Someone still has their mic and it's not muted, please. I'm sorry, Mr. Harper, if you would answer Justice Kern's question.
Yes, Judge. So there are two theories that would justify the allocation of legal fees in this case. The first is as against the estate for a financial benefit to the estate. However, the case law providing that a beneficiary's legal fees can be allocated against the estate does not necessarily require that there be a financial benefit to the estate. For example, in matter of Wilshire's estate, the appellate division in the 3rd Department found that an attorney could have his legal fees charged against the state beneficiaries, charged against the estate ultimately by virtue of the fact that the attorney's legal services resulted in a benefit to the estate in the form of figuring out who the beneficiaries were, as well as identifying how the estate's assets would be distributed. Likewise, in matter of Paletto, the surrogates court found that the efforts of the distributee's attorneys that resulted in a later will than the one initially offered for probate, ultimately being admitted to probate, demonstrated greater respect for the testator's testamentary intent. And here we have an example of how there was a non-financial benefit that would justify allocating Robert's legal fees as against the estate. The decedent unquestionably intended for Robert to receive the benefit associated with her interest in Florida Flats. And to the extent that Robert took the affirmative step of protecting the estate's interest as it relates to Florida Flats at a time when Edward, who was conflicted and favoring his personal interest as a beneficiary of a related marital trust, Robert's legal fees are properly chargeable against the estate. Now, the respondent's reliance on matter of Hyde, a case from the Court of Appeals in this progeny, to establish that the petition was properly dismissed is not justified. Taken collectively, the factors articulated by the Court of Appeals in Hyde weigh in Robert's favor because there was a benefit in terms of one half the interest in the sales the proceeds derived from the premium for Florida Flats. There was, in addition, and equally importantly, a commission denial against Edward that in order to the benefit of the estate, and the 2nd Department recognized in matter of quatrosi that justifies an allocation of the beneficiary's legal fees against the estate. Even putting that aside, there is an independent basis for shifting.
Let me go back to the commission issue, because wasn't the commission going to go to the brother Edward, who was the residuary residuary beneficiary anyway, so it was sort of meaningless. It was not a benefit to the estate if he lost the commission because it would have come to him anyway as the residuary beneficiary.
Your Honor, it wouldn't have impacted his interests as a residuary beneficiary of the estate, but it was a benefit to the estate.
The estate, because the estate, it makes no difference to the estate overall, basically.
Well, Judge, respectfully, it does. But even putting that aside, there's another independent basis that justifies shifting Robert's legal fees, not just to the estate, but also against Edward individually. And that is the principle that this court recognized in matter of Duell, that a fiduciary's wrongdoing that is exposed by a beneficiary's legal fees justifies shifting from the beneficiary to the fiduciary the legal fees that the beneficiaries incurred. The underlying rationale is that the beneficiary—
Thank you, counsel. You're a little over your time. I want to move on.
Thank you.
To Ms. Cascove. You have 1 minute rebuttal. Mr.
Thank
Thank you. This is David Cascove. May it please the court. I represent respondent Edward Korn. I'd like to just directly address some of the points that opposing counsel has just made. First of all, as the panel notes, the benefit that applies here went totally and only to Mr. Korn, the appellant. Therefore, there was no benefit to the estate.
Nevertheless, your client was found to have— What's going on? I'm getting terrible.
Yeah, we all are. I can only ask that everyone turn off their mics, please.
Your client nevertheless was found to have violated the fiduciary duty.
That is correct, Your Honor. For context, the objectant filed 45 objections, of which only 5 were upheld. This was a complicated situation in which Mr. Edward Korn, was wearing 2 hats as 2 fiduciaries. But the point is that the law is quite clear that simply a finding of a breach of fiduciary duty without a benefit to the estate is not a basis for an award of legal fees. There's not a single case that appellant has put forth that supports that proposition, because no court has supported that proposition. Here we're looking at the cases that appellant relies on are for benefit to a party are either kinship cases or cases where a party acts in a manner that wastes the court's time and causes cost within the context of the proceeding itself. That is certainly not something that happened here. The court is quite clear, the surrogates court applied the Hyde factors, if I may quote, is that in the exercise of discretion and weighing the applicable factors set forth in Hyde, the court determines that Robert's fees should be borne by him personally and not by the general estate. The surrogates court applied the factors, which is what it was required to do, and it did so correctly, Your Honor. So this appeal turns on the question of whether the surrogates court properly exercised its discretion when it dismissed appellant's petition for legal fees. It's quite clear that in weighing—
Are there any further questions from the panel? Thank you. Mr. Harper.
Mr. Harper.
Yes, Your Honor, very briefly. First, with respect to this issue of discretion, of legal fees may be a matter of— However,
I'm just going to ask again, if you would please, counsel, check your mic. Please, all of you, check your mics. Make sure that you are muted unless you are Mr. Harper. If you would continue, Mr. Harper.
Yes, Judge. With respect to the issue of discretion, ultimately the allocation and award of fees is a matter of the surrogate's discretion. But that is not equally true where the motion comes before the court as part of a CPLR 3211 motion to dismiss before an answer is filed. Court of Appeals precedent makes clear that the standard of review is not one for discretion of the surrogate at this juncture of the proceeding. Now, briefly, with respect to counsel's point that there are no cases stating that in the absence of a benefit to the estate, that The legal fees of a fiduciary incurred by a beneficiary should not be allocated against the estate. Well, that's why we have dwell in the proposition that where there is an establishment of wrongdoing on the part of the fiduciary individually can be held personally responsible for these legal fees. The surrogate reached that conclusion in Dwell. This court modified, but in modifying, it actually increased the amount of legal fees to be charged against the fiduciary, which we respectfully submit supports the respondents or the appellant's position, and this court should reverse the order of the surrogate. Thank you.
Thank you. Thank you both.
Thank you, Your Honor.
Sotakos versus TSE Group.
Good afternoon, Your Honors. Can you hear me? This is Carla Variale Barker, and I represent the defendant's appellants.
Thank you.
You're welcome. Briefly, this is a trip and fall accident on a staircase inside of B.B. King's nightclub, which is no longer with us, but it was a fixture in New York. It is a nightclub, and this particular plaintiff had traversed the same set of stairs earlier in the evening. She was there for a concert. We did produce the manager. We produced information about the diligent maintenance.
Counsel, aren't there questions of fact here that are for a jury to decide?
No, there aren't questions of fact. For example, the maintenance and inspection records include an inspection done minutes before the accident happened.
And yet there was definitely a defect or something in the stairs. There's the bulging of the stair that is not a transient issue. So didn't happen overnight, didn't happen within the 30 minutes. And there are other questions of fact. Why isn't that a reason why you should not have been granted
There's
summary
no
judgment?
evidence. There's no evidence that B.B. King's created this defect. There's no actual notice. And with respect to constructive notice, I'm hard pressed to find a situation where there was another circumstance that the inspection occurred before the event and minutes before they were exiting the event.
Counsel, didn't one of the employees actually testify that that condition had existed there for some length of time, for years before the accident occurred?
No, I believe that Mr. Andrade's testimony was that carpeting existed, not that the condition did. In fact, his testimony, I think this is.
But his testimony was that he worked there for 4 years and there had been no repairs of any kind to the stairs in 4 years. And yet there's a photograph of the bulge that was identified and recognized by Mr. Andrade, which he said that had he seen, he would have repaired. So whatever it is was there because the stairs had never been repaired. And it's not something that was transient and would have just come up.
Well, that's actually a bit at odds with the record. Mr. Andrade testified that he did not, and he was the person that conducted the inspection. And those photographs were not taken at the time of the accident. They were taken later. And that was something that was discussed in the order below. I think that one of the reasons that the court denied summary judgment as well was that the lighting conditions were dim. It's a nightclub, and this particular plaintiff admitted she did not have any trouble seeing anything in front of her. The accident report is devoid of any description of the lighting conditions and indeed like a bunch in the carpeting. The way that she testified the accident happened, it's the same staircase she had traversed earlier in the evening. And her toe got caught underneath. I mean, given her own testimony, for all we know, and the plaintiff offers speculation about this, that the plaintiff herself could have caused the condition. We know that it was inspected.
Thank you. You have 1 minute rebuttal. Thank you.
Thank you, Your Honor.
Mr. Woolwick?
May it please the court? If the court has no questions for me, I'm willing to rest on my brief.
Well, I have a question. The pictures weren't taken for a month after the incident occurred. So counsel's saying, well, maybe it wasn't there.
That's correct, Your Honor, but the Mr. Andrade, the manager of the facility, testified. He was asked, is this photograph fairly and this is the photograph exhibit A where the plaintiff marked her initials where she fell and what caused her to fall. Does it fairly represent what the staircase looked like on the night of the accident? And he says, yes. That's how it looked, yes. So
you feel there are questions of fact?
Yes, Your Honor.
Any other questions from the panel? Thank you.
Thank you.
Back to you, Ms. Barker.
Yes, just briefly, if you look at the record at page 182 to 183 roughly, he is careful, Mr. Andrade, to say that he's talking about the carpeting. And he makes it clear that if he would have seen a condition like a bump or a hump on the staircase, he would have had maintenance take care of it, but he didn't. And that's documented. I don't have anything further for you. Thank you so much.
Thank you. Thank you both. Aquero versus Nelson.
Yes, may it please the court. This is William Badura on behalf of the Appellant Motor Vehicle Accident Identification Corporation, also known as MVAIC. This appeal was brought from an order which denied the motion of MVAIC to dismiss the complaint in lieu of serving an answer on the basis that the plaintiff did not follow the procedures set forth in Article 52 of the insurance law. Rather than following those procedures, which included filing a notice of claim within a certain time period.
Counsel, the individual was an infant at the happening of the event, and once he reached the age of majority, and I think had filed with MVAC initially, maybe didn't continue it because they thought someone had been arrested, but shortly after filing the action, upon reaching the age of majority, he learned that the person who they thought was the driver was not, and that there was no driver found. Why isn't that sufficient here?
Because just going back, this accident happened back in November of 2008, and during that same month, the plaintiff's attorney wrote a letter to MVAIC just requesting no fault in that application, not putting them on notice with respect to filing a notice of claim.
Well, you knew about the event at that time. You were aware of it. I understand it's not notice according to this, but are you prejudiced at all? According to the statute, are you prejudiced at all by this? I mean, you had the facts of the case then, you have the facts of the case now. That's what MVAC does. MVAC comes in when there's no known driver. It doesn't seem like there's anything that you learn now that you didn't know then. I might be wrong, so let me know.
There's 2 points in that. With respect to the prejudice, really MVAIC was not put on notice with respect to this accident until it received the summons and complaint, which was filed on December 21st, 2018. The simple letter requesting a no-fault application doesn't put MVAIC on notice. To put MVAIC on notice pursuant to the statute, you have to follow Section 5208 of the insurance law. And more particularly, you have to file within 180 days after the cause of action accrued, which is the date of accident, when there's a situation like this where there's no insurance, where there's an identified vehicle and a question of permissive use, which would lead to the question of there being no insurance. But again, the article, Section 5208, only gives them 180 days to do that. And furthermore, without any requirement or exception for infancy, 5208C specifically says that notice of claim must be filed within 1 year, even if it cannot be filed within 180 days as required by 5208B. So again,
thank you.
MVAIC has statutory obligations it must follow, as well as a claimant, which we're not.
You have a rebuttal time.
Mr.
Rubenstein?
Yes, Your Honor. May it please the court.
Mr. Rubenstein, what do we do about the 5208 notice?
Again, Your Honor, I think adversary counsel is acting under a misapprehension. All the case law he cited in his whole argument is based upon the fact that MVAC argued that there was no infancy toll in the statute. We presented case law that the statute was amended, and based upon the amendments, the infancy toll does apply. I'm talking about the Steele case and the Johnson case that we cited from this court, which explicitly provided for the infancy toll and allowed claimants in those cases to proceed. The court has broad discretion. There's no argument that discretion was abused. Ms. Schlossman submitted an affirmation saying that the client was qualified. I don't think there's a dispute that he was qualified. There was no reply affirmation submitted to dispute that as well. Indeed, MVAC did not even argue a claim of prejudice in its moving papers. It raised it for the first time in its reply appellate brief.
Thank you. We're back to you, counsel. Your mic is on. Yeah.
Yes, Judge. Just very briefly, with respect to the prior case law, that's Earhart versus MVAC, decided by this appellate division back in 1976. That case interpreted section 608 of the insurance law, which was subsequently amended to 5208. And more specifically, right in the Earhart case, they said that 6208 basically says the same thing as 5208C now with respect to an infant's not relieved of its failure to file a notice of claim as is required by that statute within 1 year. So again, the prior case law in my opinion stands, and if there's no further questions, I will rest.
Thank you. Thank you both, gentlemen.
Thank you.
Thank you, Your Honor.
Mendler versus Jane Horatio.
Good afternoon, Your Honors. May it please the court, Andrew Akron on behalf of Silverman, Shin and Byrne on behalf of the appellant. Your Honors, this case involves...
I'm sorry. I am sorry I skipped a case. My apologies. I'll get right back to you. People versus Bobby Rock.
Good afternoon, Your Honors. Anjali Padmanathan on behalf of Mr. Rock.
I apologize.
Not at all, Your Honor. In this case, Mr. Rock pled guilty to assault in the second degree, and he was sentenced to 6 years in prison with 5 years of post-release supervision. We're asking Your Honors to exercise your interest of justice jurisdiction to reduce his sentence to the minimum of 3 years of imprisonment or something closer to the minimum of 3 years. Mr. Rock is a father of 2 young children and was a financial provider for them before his incarceration. Where the adverse effects of his incarceration on his children is evident from social science, as I've cited to in my brief, we submit that there's no social benefit for Mr. Rock's prolonged incarceration. If the goals of penological sanctions are to benefit society, parental incarceration should be as limited as statutorily permissible to ensure the negative impacts of imprisonment, to ensure that those negative impacts don't needlessly spill over to future generations. And additionally, at the time of
I'm a little confused about the facts of this case, because from what I could see from the briefs, there it was an unprovoked assault, an unknown victim, and maybe Mr. Rock should have given some thought to his children before he attacked this individual.
Your Honor, it's true. There's very little information on the record about the facts of the case. It is an unknown complaint. There's no record of how any interaction between them came about. But at the end of the day, Mr. Rock did plead guilty. He admitted to his offense. He pled guilty to assault in the second degree, and he's not contesting his conviction.
No, but you're pleading the case for the benefit of his children, which I'm quite sympathetic to his children. But the first thought of Mr. Rock should have been for his children and what the effect of his acts would have on his children.
Your Honor, certainly, but an assault 2 conviction for a second nonviolent felony offender has a sentencing range of 3 to 7 years.
Right, but this covered 2 cases, and he has a YO for assault in the third. He has convictions in New Jersey. He has 14 convictions in New York.
Your Honor, the YO, first of all, it's a youthful offender, and so it's not considered a conviction. It was an assault 3, which is a misdemeanor, and it was from 2003 when he was a teenager. So it's obviously that is the only hint of any history of violence in Mr. Rock's record. his convictions, the rest of his convictions in New York and New Jersey, they are all theft related. They're not related to any violent history.
He obviously has a drug issue, and that's propelling a lot of his behavior.
Your Honor, there's no record of that in the record before us on this case. What I can say is that at the time of this incident, at the time of his sentencing.
I don't mean to interrupt you, but I thought the brief said that the convictions were for drugs and theft-related cases.
Certainly, Your Honor, yes, but the last drug-related conviction was from 2005, which is more than 10 years before this incident. So there's no assertion at this point in his life that there was any drug-related conduct going on in Mr. Rock's life. At the same time, we have evidence that he was working lawfully for Fresh Direct here in New York City. He had prior to that had a job at a construction company in Queens called Blueberry Builder. He had attained his GED. He was taking care of his family. In fact, the lower court kept him out pending sentence for an additional adjournment because he had serious family conditions going on and was obviously responsible for taking care of those issues. And so for all of those reasons, he's not deserving of more, substantially more than the minimum sentence here, where the minimum is 3 and he was sentenced to 6 and the max is only 7. We submit that nothing in these facts suggests that he should be at the highest.
I'll ask it on rebuttal. Thank you.
Okay, thank you.
Counsel, Mr. Lewis, I believe.
Yes, Jillian Lewis for the people.
Ms. Lewis, sorry.
May it please the court. Good afternoon, Your Honors. Here, the defendant was charged with originally 2 counts of first-degree assault and 2 counts of second-degree assault. And he was able to dispose of the entire indictment by a plea to the second-degree assault charge, which came along with...
Was there another indictment, or was it just 2 charges on the one indictment?
It was 2 charges of first-degree assault and 2 charges of second-degree assault. And with that, he was able to dispose of all of that and a pending additional charge, I believe, with the promise of 6 years in prison and 5 years.
When you say a pending additional charge, we're talking about 1 indictment or 2?
There was the 1 indictment, and then there was an arrest that had not yet been indicted that was also disposed of during the plea agreement.
And what was that other arrest for?
I believe it was a misdemeanor.
Okay, so there would have been no indictment. It was a misdemeanor.
Yes.
Okay, so he pled guilty to the one indictment, which is not unusual that one pleads guilty to 1 charge, and then that took care of also the misdemeanor charge, right?
In the indictment, there was the 2 first degrees and the second degrees, yes, and then there was no other pending matters before the court. And with that guilty plea,
did those refer to 2 separate incidents and 2 separate victims?
This was the initial charges was based on the initial charge with the 1 victim where he slashed the individual across.
I understand there's 1 victim where he was slashed, but you're talking about two first degree charges and 2 second degree charges. Are those 2 separate individuals who are the victims in 2 separate incidents, or is it all the same incident?
All the same incident. And with that came the an excessive sentence claim that was then foreclosed on because of his waiver that he knowingly, voluntarily, and intelligently signed. And because of the...
What was the story? I'm sorry, what was the story with the victim? There was no indication from the police or anything? The person didn't remain at the scene, never contacted?
The victim did get a full order of protection, and that was a part of the plea agreement. The victim was known to the grand jury. So even though the victim is unknown...
But was not known to the defendant?
That is not clear based on the record. But all of the things that defense counsel spoke of about the defendant being a father, about him holding a job, about his prior convictions and felonies, that was all known during the plea proceeding. So that is why the defendant ended up getting 6 years as opposed to the maximum sentence, which here was 25. And within the range of the second degree assault that he could have gotten upwards of a maximum of 7 years. This 6 years when looking at the possibility of 25 years.
Sorry, this was 2016, and he had never had a violent before except for the YO?
He had a 2005 felony for third degree, for criminal possession, I believe.
I'm asking about violence.
No,
So
he
that's
had not
violence. Yeah.
He had not had a prior violent felony, but he had other criminal charges in New Jersey that were theft.
Theft and nonviolent.
Yes.
Was this out of character then? I mean, I don't expect you to answer that really. It just seems very unusual that somebody who has a life of criminal activity but no violence would then, out of nowhere, for no reason, slash someone. I mean,
not necessarily, because the pre-sentence report indicates that it's recommended that he got anger management, that this was something that was known about the defendant. So it was something that was indicated based on the pre-sentencing report, that he had this violent tendency and could benefit from anger management. And clearly—
But this had not shown itself before any other time that he came before the criminal justice system. Is that what you're saying?
Well, there were escalating acts with the charges in New Jersey and the theft and other charges as a youthful offender as well. But
I'm not sure what you mean by escalating. It doesn't really. I think you're saying that it wasn't just. It was the charges were different, more serious, but there's no evidence of any anger or any violence in any of those. Anyway, thank you very much.
And
we're back. Thank you. We're back to you, Miss Pathnathan. I never get that right.
No, it's fine, Your Honor. I'll just say, with regards to the anger management point from the pre-sentencing report, that actually goes to our point. When the Department of Probation interviewed Mr. Rock and completed a report, that's all they recommended was anger management. They didn't recommend or suggest incarceration. Now, obviously, incarceration was required based on the sentencing guidelines, but it actually shows that he doesn't have this history, this violent history.
Hadn't he already entered it into the plea?
Yes, Your Honor, exactly. But typically when
they wouldn't be recommending incarceration because that was already part of the deal.
They wouldn't be recommending incarceration where someone's not already getting incarceration, but Your Honor, typically we'll see in a pre-sentencing report something that says this person is required to be incarcerated or is a danger to the community. This language is very common. Here what we have is he should have anger management treatment. And I think that's relevant, particularly because this is a violent felony conviction, that the fact that the Department of Probation does not indicate that incarceration is the solution is not showing that Mr. Rock had some sort of escalating tendencies of violence or that he had presented any information that suggested that he was, quote unquote, becoming a more violent person. Under the circumstances, there really isn't any reason why he was sentenced to 6 years in prison rather than something closer to the minimum of 3. And so we ask, Your Honors, under these circumstances, to exercise your discretion in the interest of justice to reduce his sentence.
Thank you. Thank you both.
Thank you very much.
Lewis, Ms. Pathnathan, thank you very much.
Thank you.
Okay, now it's Mendler versus Jane Horatio and Mr. Acheron.
Yes, Your Honor. Thank you. May it please the court, Andrew Acheron from Silverman, Shin & Byrne on behalf of the appellant. This matter stems from the interpretation of a separation agreement between a husband, Henry Mendler, and his wife, Judith Mendler. It deals with the distribution and the allocation of 6 properties, among other things, but in relevant part of 6 properties.
It seems like this argument turns on the question of sale and distribution. And of course, there are a number of other issues, but with regard to sale and distribution, is there any definition within the agreement?
Your Honor, the term used in the agreement is selling and conveying. No, there is no specific—
Selling and conveying, I'm sorry.
Yes, there is no definition within the agreement of that term. However, I will note that with regard to
this is Judge Cohn. Why is selling and conveying? You're arguing selling and conveying is just selling. And I'm just on its face, how can selling and conveying be limited to only selling?
Your Honor, thank you. the term selling and conveying, when used in this particular paragraph, incorporates a different approach to this particular property than used throughout the remainder of the agreement. And in analyzing the entire agreement and this term in that context, the term selling and conveying should be read as conjunctive. Selling and conveying, not permitting Henry, the husband, to simply gift the property. That's because in this regard, the property at issue was transferred to Henry subject to two conditions. One being a second mortgage held by Judith Mendler, and the second being a provision that required that in the event that Henry sold this property, Judith was entitled to 50% of the net proceeds. This is the only at issue in the agreement, which includes a future right of the.
Before you go on, I'm just coming back to this. It seems somewhat unambiguous, that term. So it sounds like you're trying to argue that something's unambiguous should be construed based on the surrounding circumstances. But why should selling and conveying mean anything other than selling and conveying?
Well, Your Honor, we agree that it means selling and conveying, conjunctive and conveying, both. Respondents will argue that it means or, and to do so, they rely on a 1925 case from the First Department from this court saying that the court can substitute or unless the word and is supposed to be construed by its literal context. And in doing that, in analyzing whether or not the drafters intended the word to be and to be interpreted literally, you have to examine the context in which the word is used. And in this provision, with regard to this property, selling and conveying should be construed as requiring the sale of the property, otherwise allowing Henry, the husband, to simply gift the property.
Counsel, though. That's what I'd like to explain. If it's just selling, why would you have to use the word conveying? Why wouldn't selling by itself be sufficient if it was limited to selling?
It would be, Your Honor, but the intent of the parties and the intent of the drafters through the use of selling and conveying in this provision, along with the context of subject to the provisions of this agreement, which required that in the event Mr. Mendler sold this property, again, this particular property, that Mrs. Mendler was entitled to 50% of the net proceeds. No other property had that requirement. No other property included in the bequeathal provisions the phrase subject to the provisions of this agreement. It shows the clear intent of the drafters that this particular property be treated differently.
But counsel, where in the agreement does it say if he doesn't sell it but gives it away, the result should be different in terms of her 1/2 interest? Where is the support in the agreement itself, in the language of the agreement itself, for the position you're taking?
Your Honor, if in the agreement, when it lists out the different properties being allocated as part of the separation agreement, it is silent as to whether or not this property could be gifted. In contrast, with regard to the properties that Judith Mendler assumed as a result of the separation agreement, the provision says that nothing shall be construed to restrain her from selling or otherwise conveying. The fact that the drafters used different terms to define the rights of these parties with regard to the properties shows that the drafters intended that this provision, selling and conveying subject or encumbering subject to the provisions of this agreement, the drafters intended it to be a sale of the property, not a gift of the property. To interpret it otherwise would render Mrs. Mendler's right to 50% of the net proceeds of the sale of the property a nullity, because Henry could just simply gift the property away. That could not have been the intent of the parties. The intent of the parties had to be.
Why couldn't it have been the intent of the parties, though? I mean, you're saying it couldn't have been the intent, but why couldn't it have been the intent, which is that if he sold it, she was entitled to half the proceeds, but he never gave away the right to give it away to someone while he was still alive?
Because, Your Honor, if to interpret it that in that way, the sale provision would become a nullity because he could give the property to somebody or give the property to an LLC, sell it through the LLC, and keep all of the proceeds. It allows him to evade the consequence of the sale provision. It also allows him to evade the consequence of the bequeathal provision. The bequeathal provision requires that if it's still in his, if Mr. Mendler is still the owner, which we contend he is because he was not permitted to transfer the property without it being a sale, he could evade the entire ramifications and consequences of the agreement. The intent of the parties should not be interpreted to subject Mrs. Mendler to the sole discretion of Mr. Mendler with regard to simply giving the property away for no profit, for no value, which is exactly what he did here.
Thank you. You have rebuttal.
Thank you, Your Honor.
Mr. Younger?
Mr. Younger, you're muted.
Hello, for the respondent, I don't
Hear
see.
you.
I don't see
You're
or.
muted.
It was brilliant before I turned on the mute button. I think the key clause here is not sell and convey. It's the clause that says only in the event that Henry still owns his property does he have to bequeath it. Sell and convey is just belts and suspenders. It says just in any event, he's not giving up his rights. And by the way, the exact same sell and convey language appears for Mrs. Mendler's properties in Dutchess County. She got the right to gift under the exact same language. It's at page R69. I think the key point is he admits the contract's silent about gifting. They had sophisticated lawyers. If they wanted to bar gifting, they should have put a clause in to say that. And that's the Blackman case from the Court of Appeals. The Court of Appeals has said, if you want to tie up somebody's property rights and tie up their inheritance rights, you have to be express about it. You can't just do this by implication. Otherwise, your honors are rewriting a contract. You know, it's not for the court to write the contract, it was for the parties. The second point is that all of these claims are untimely. These transfers happened over 10 years ago. The theory of his case is that there was a bar on gifting. That gift happened a decade ago. And so under any theory of this case, as Judge Sherwood found, the case is untimely. But there's another point, which is the fraud claim, which, you know, and I'd like you to look in the record if you could, because it's critically important. At page 235 of the record, a dozen years ago, in the record, there's a deed saying there's another member. How is he not on notice? And by the way, in 2010, his own client, the son, signs a deed as the manager of this enterprise. Why didn't mom ask the son what's going on here? So in short, your honors, in our view, the only way that the appellant could win here is if your honors rewrite this contract. That's not the province of a court. That's what was supposed to happen when these two sophisticated lawyers got together and wrote this contract. And, you know, respectfully, we would just ask the court.
What about the statement he did make in the prior litigation in this case where he said, oh, yeah, I understand I'm not going to sell it, that she's entitled to half of it?
Actually, read the ellipses. Go to page R352, which they didn't include in their brief. He says, I insisted upon total freedom, not only to sell the property, but to deal with it without any restrictions whatsoever. He said, title passes to me. Absolutely. Absolutely. Now, remember, this is in the 1974 case. They never included that part in their brief. That's the 352 to 53. The issue about gifting wasn't even an issue in 74. It didn't come up until 76. And in 1976, she made a claim, the same claim she's making now, that he didn't have the power to gift. Judge DeGrasse dismissed that claim on the merits. That claim was dismissed in 1976. So in 1974, when he wrote that affidavit, gifting was not even on the horizon. It wasn't even an issue. But he said there are no restrictions whatsoever. I have total freedom about this property. And by the way, there's another clause which I think is quite important, and that's not mentioned, which is the transfer clause. They transferred all the past, present, and future interest in this property to Mr. Mendler. How can there be a restriction like he wants if they gave him fee simple absolute? How can you sell the property if it's subject to all these restrictions? How could you have the right to mortgage it? Under their own theory, Mr. Mendler could have taken out the entire equity in this property through a mortgage. He could have condoed it. He could have turned it into a trust. But just because it's not mentioned in a savings clause, that doesn't mean when you get a fee simple absolute in a property that your hands are tied. Yeah, if you want to tie somebody's hands when you transfer them property, you have to put a clause in the contract. Unless there are other, I'm sorry.
I was just saying thank you.
Yeah, unless there are other questions, I think that it's time for these multiple litigations to finally be put to an end. Thank you very much.
Mr. Acheron?
Excuse me, Your Honor, did you want to hear the cross appeal?
With the cross appeal.
Oh, I'm sorry, you're right. Yes.
Sorry,
thanks.
yeah. Gerard Riso, may it please the court. I'm going to be heard, if I may, on the cross appeal.
Yes, yes.
Which is the only cause of action that survived. The cross appeal, it deals with a separate issue concerning Judith Mendler's rights to continue to occupy
and have someone
former marital apartment at 11 West 11. She had conveyed the building to him as part of the agreement. He agreed, okay, you could stay there.
You can stay there without having to pay any maintenance or anything else, and that wasn't paid, and she makes her claim for that.
Except it was paid, and that's why Judge Sherwood, we respectfully submit, should have dismissed this because she had never pled or could prove damages. Counsel admitted at oral argument, and that's in the supplemental record at page 50, that her son, Joseph Mendler, paid all the maintenance fees when Henry Mendler, the father, made the decision in March 2016 to stop paying those fees himself. So Judith Mendler never paid any fees. Judith Mendler's right to live in that apartment for as long as she wanted, rent-free, were completely honored. She never paid a penny.
Well,
she was never damaged.
Counsel, doesn't the agreement say, though, that he will pay the maintenance fees until her death? Not that somebody will pay the maintenance fees, but that he will be responsible for the maintenance fees up until the time she passes away.
No, it really doesn't say that. What it says is that he can convey the building subject to the protections afforded to her in the agreement. And he did that when he conveyed the building in 1983 to the cooperative ownership. If Your Honor looks at the offering plan, which was submitted by the appellant below, the excerpts are at page 474 and 510. In the offering plan, the cooperative specifically recognized Judith's rights to stay in that apartment rent-free. And what Henry Mendler agreed to do was to guarantee the maintenance payment if a subsequent holder of those unsold shares didn't pay it. So when he conveyed
keep paying it, though, even after he sold it to his son? I mean,
yes, he was.
Many years after his son took over the apartment, he was still paying the maintenance and recognized his obligation to pay the maintenance.
Well, he didn't pay it out of a legal recognition. The contract of sale was also put in by appellant, and it in the record at page 470, paragraph 39, Joseph Mendler specifically agreed to assume Henry Mendler's obligations as the owner of those shares under the offering plan. That is the obligation to continue to permit his mother to live there rent-free. So when Henry Mendler said to his son in 2016, I'm not paying your obligation anymore, he was within his right to do it. The offering plan in the contract of sale specifically required Joseph to pay it. Joseph never made a claim against his father saying, hey, how come, why do I now have to pay? This didn't come up until much, much later as a tag-along to this other lawsuit. This is not a claim by Joseph Mendler. Joseph Mendler recognizes his obligation to pay the maintenance. His mother never had to pay the maintenance. She got the benefit of her bargain. Joseph assumed the obligations of that bargain. Henry only agreed to be liable as a guarantor to the corporation, but only in the event Joseph failed to pay. Joseph didn't fail to pay.
Thank you.
Thank you.
Mr. Acheron, I think we're back to you.
Yes, thank you, Your Honors. First, in an effort to correct, just to make sure that the court is clear, the prior litigations that Mr. Younger referred to were in 1994 and 1996, not 1974 and 76. But in regard to those cases dealt with whether or not Mr. Mendler had the right to prepay the second mortgage held by Mrs. Mendler on the property. They did not involve, and the issue was never reached as to whether or not the property could be gifted. That claim was not actually litigated, as Justice Sherwood properly found. With regard to the statute of limitations argument advanced by Mr. Younger, when a promisor obligates himself to make a testamentary disposition in favor of a specified person, that cause of action for breach of that obligation only accrues upon the death of the promisor, as this court found in Brown versus Brown in 2004. The obligation to to will this property to Mrs. Mendler didn't accrue 2018. It was only at that point that Mrs. Mendler's claim to and right to this property arose. That the property was previously gifted away in a potential breach of the separation agreement does not create the right to bring a suit for breach of the bequeathal obligation, as this court has found. With regard to the agreement, and just turning back to the agreement for a moment, the court has an obligation to analyze the actual text used. And what respondents have claimed here and what they've advanced is not that we're asking the court to rewrite it, but they're asking the court to rewrite it. They're saying, don't interpret the word and as and, interpret it as or. And the clear provision, and Mr. Younger was also incorrect about one other thing, the provisions, the bequeathal provisions are not the same. The bequeathal provisions with regard to Mrs. Mendler's properties do not include the term subject to the provisions of this agreement, whereas the bequeathal obligation with regard to this property does. And that's because of the sale provision, that Mrs. Mendler was entitled to 50% of the proceeds of the sale of this property. There's no other reason to include that term in that specific provision while not including it in any other. This property was being treated differently by the drafters. The party's intent was that this property be treated differently. That Mrs. Mendler was allowed to gift her properties is irrelevant to the analysis of whether or not Mr. Mendler was allowed to gift his property, this particular property. With regard to the cross appeal, just quickly, Mrs. Mendler, Mr. Mendler is not saved by the fact that Joseph, his son, started paying his obligation. The liability of Mrs. Mendler accrued to Joseph upon his starting to pay that obligation. The claim that Joseph didn't sue his mother for that obligation is irrelevant to the fact that the estate, Mrs. Mendler, had the claim against Mr. Mendler continuing for the payment of the maintenance fees.
Thank you.
Thank you, Your Honors.
Thank you all.
Thank you, Your Honor.
Neary versus New York City Transit Authority.
Thank you, Your Honor. We feel that this is a garden variety application of the emergency doctrine. Plaintiff argues that the bus driver contributed to the happening of the accident by violating a code provision about, yielding to pedestrians in a crosswalk. Our response is two. One, he did yield to the pedestrian in the crosswalk. And two, we cited DePonzio for the Reardon for the proposition that violation of a code provision is relevant only if the code provision was addressed to the risk that led to the injury. In this case, the code provision is addressed to the risk that a pedestrian will be run over by a vehicle, and it is not addressed to the possibility that someone riding on a bus might be injured. And the point I wanted to make on this today is that in her respondent's brief, plaintiff had absolutely no response to the DePonzio point. If there are no questions, otherwise we will rest on our brief.
Thank you.
Thank you.
Eros International versus Mangrove Partners.
Good afternoon, Your Honors. May it please the court. Scott McLagan on behalf of defendant appellant Manuel Asensio, who respectfully requested this court vacate the decision and order of the court below and grant the appellant leave to move to dismiss pursuant to 3211. Your Honors, this appeal is based on the question of whether appellant was properly served by the respondent. The first time the question of service of process was addressed was in February 2018, when Judge Branston heard the respondent's underlying motion for a default judgment. At that time, Judge Branston noted that due to the inconsistencies and discrepancies in the affidavits of service, in Judge Branston's words, quote, "This court cannot determine service was properly made." And that's in the record at page 37. Indeed, Judge Branston noted that due to the discrepancies and inconsistencies in the affidavits of service, again, quote, "absent testimony," Judge Branston said, such discrepancies could not be resolved. Thus, Judge Branston set the matter down for a Travers hearing. That Travers hearing was held in June of 2019 before Judge Cohen. And at that hearing, the respondents failed to procure the appearance of the process server, Mr. Guskin. Instead,
But they were used the affidavit, and in addition, they had someone with information about the facts testify, didn't they?
Well, Your Honor, the Judge Cohen had issued an order back in May of 2019, ordering the parties to exchange witness lists a week before the Travers hearing. On respondents' witness list, they did not include the process server. They included two attorneys from the respondent's former counsel.
I understand. And one of the attorneys didn't have the factual basis, the knowledge, and so another witness, I don't know if it was an attorney, another witness was permitted to testify.
That is correct, Your Honor. Over the appellant's objections, the respondent was allowed to call the other attorney, Ms. Gow.
Within the discretion of the justice, I think.
Yes, Your Honor. However, since they were seeking to use the shield of CPLR 4531 and declaring that their process server was unavailable, the fact that the only person with firsthand knowledge as to whether or not the respondent's firm made diligent efforts, which was their burden to show by preponderance of the evidence that they made diligent efforts to procure the appearance of the process server. There was only one individual that had that firsthand knowledge. That person was not included on the witness list, and appellant's objection, Judge Cohen permitted that witness. Interestingly, in order to rebut that, the issue of service of process, the appellants attempted to call two witnesses that had not been noticed a week before as required. They had only been noticed the day before. Judge Cohen refused to allow those two witnesses to testify. And so that's another basis of the appeal, is that these unilateral sanctions of preclusion were...
Well, I think it was more than that. I think that there was an extensive hearing before, and there was a request that the papers be submitted with the witness list. It wasn't done. I think a subpoena had been sent out much earlier that showed that they had intended to call this person all along, and then nothing happened until the night before. It was within the discretion of the judge, wasn't it, to determine whether or not they believed that that was willful or not. So I guess based on that, the question is, did the justice abuse discretion in these circumstances, given the facts that were before the court in terms of the witnesses that
yes,
were permitted to testify?
I'm sorry, Your Honor. Yes, and the abuse of discretion is in the fact that both parties attempted to call witnesses that were not noticed according to Judge Cohen's prior order.
Well, that makes it simple. That makes it seem equal. But when you look at the circumstances leading up to the reason why one was permitted and the other wasn't, it's not quite as equal.
Well, Your Honor, it's appellant's position that the respondent was aware that in order to meet their burden to prove unavailability, that there was only one fact witness that they could call. They failed to include that witness on the list. In order to meet their burden, they needed that. Otherwise, all they had was hearsay testimony.
I understand. Thank you.
Great, thank you.
Mr. Elbert?
May it please the court. My name is Chad Elbert, counsel for the respondent, Eros International PLC. And to begin,
Counsel, if you just answer the question with regard to the where your co-counsel, where your opposing counsel left off, that you didn't have your witness, you had a different witness, the court allowed you to call your witness.
absolutely, Your Honor.
Was that an abuse of discretion?
Your Honor, I think this was completely within the discretion of the trial judge. And I would say that we're being presented with a false equivalency here. The facts were that the judge had ordered that all briefing with respect to the Traverse hearing and the identification of all witnesses that would be presented at that hearing be exchanged on June 6th. In Eros's submissions in response to this court order, we had extensive briefing and declarations setting forth exactly what Eros intended to present at that hearing. We received nothing from the appellant. In fact, the appellant ignored the deadline, and then the day before the Traverse hearing was to occur, we received this late notice of 2 witnesses. At the actual Traverse hearing, a partner at Kasowitz took the stand to make the uncontroversial point that he can testify as to the firm's files. The firm's files including the relevant correspondence between the process server and associates and Kasowitz's managing clerk. The opposing counsel objected to this. The judge noted that he's never heard such an objection because normally a partner at a law firm is permitted to testify as to his firm's files and employees. Rather than engage on this specific issue, because the associate that did have direct contact with the process server was in the courtroom, and because these exact topics were fully disclosed to the court and to the appellant prior to the hearing, the judge exercised his discretion to avoid this issue about the partner and allow the associate to take the stand. On the other hand, on the other side of this, because the appellant failed to produce anything on June 6th, and in fact sent subpoenas the day before the Traverse hearing that, as Your Honor noted, were dated June 5th, the court in its discretion determined that this was purposely done in order to surprise the parties at the Traverse hearing. And the court said at this hearing, court orders need to mean something. And so under these circumstances, the court rightfully determined that this is not a false equivalent, this is a false equivalency, and that the appellant should not be permitted to spring these witnesses on Eros, while Eros was perfectly within its rights, particularly in light of the appellant's objections to put their witness on the stand.
Thank you.
And I'll note with respect to these service issues, Your Honor.
I thought you were done. Okay. If you would wrap up.
Oh, with respect to the service issues themselves, Your Honor, I would just say that the process server undeniably served 5 different occasions at Mr. Instancio's home on weekends, on weekdays, and there really is no dispute that service was proper in this case, and the court was in its discretion to find as much.
Thank you. Mr. McLagan, sorry.
Yes, Judge, thank you. Just very briefly, with regard to the respondent's burden, the respondent had the burden at the Traverse hearing to show by preponderance of the evidence that the process server was unavailable. Even if this court agrees with Judge Cohen's discretion to permit Ms. Gao to testify. Nothing at that Travers hearing resolved any of the issues of Judge Branston's decision to set the matter down for a Travers hearing. There was no firsthand testimony given by Ms. Gao or anybody else at the hearing who could clarify the discrepancies and the inconsistencies in the two different affidavits of service. And Ms. Gao was even questioned during her testimony, and this is at page 182 of the record, as to whether or not she sought to get a supplemental affidavit from the process server and her response was no, she did not.
Thank you.
Great, thank you, Your Honor.
Thank you both. Okay, I understand, Mr. Elbert, you're back on the other appeal. Mr.
Yes,
Elbert, okay.
May it please the court, my name is Chad Elbert, counsel for the appellant, Eros International PLC. Now, Your Honors, this is undeniably a complex case, but right now, the question before the court is simple and narrow. Is there a single statement in Eros's amended complaint that is reasonably susceptible to a defamatory connotation? Now, that standard comes from the Court of Appeals opinion in Davis v. Boheim, and that court acknowledged that such a liberal standard must apply to defamation cases, notwithstanding First Amendment concerns, based on the historic and important right for an individual to seek redress and to protect his reputation against defamatory attacks. Now, this case is about a group of short sellers who conspired over a period of several years to publish false information about Eros with a specific intent to trade on that information to their advantage. Now,
so counsel, we have tweets, we have articles, we have some other, let's see, tweets, articles that have a number of different statements in them, but the Court of Appeals also indicates that we have to look at the precise meaning that's readily understood. We have to look at the context. We have to see if the statements are capable of being proven true. And I mean, we can take the statements in separate groups, but these statements seem to be, in general, they seem to be speculative, or they seem to be opinion. Most of them have "I believe" or "should," and they also seem to have the facts associated with the basis of the opinion, or at least a link to it. So when you can go to the facts and look at the facts and make a determination, is this something that's actionable?
Your Honor, I think it would be helpful to look at particular statements in view of answering your question.
I think that's a good idea.
Thank you, Your Honor. And I believe that our focus on this appeal, as you may have noted, is on the statements from the Mangrove Partners defendants. These statements are in our brief, and they are taken from paragraphs 359 and 361 of the amended complaint. Now, these statements were not considered by the court below in rendering the opinion. And for that reason alone, we believe that this warrants demand. What's important is that these statements really are susceptible to a defamatory connotation. And these are tweets, as your Honor pointed out. But these tweets, what they say, they accuse Eros of having fraudulent revenues. They accuse Eros of having fraudulent sales, being booked and not collected, of being a complete fraud, and saying that the company is a fraud. There is no doubt any longer. And now, Your Honor, I completely agree that it is incredibly important, and Davis says so as well.
So don't they give underlying basis for the opinion, though, when they make that statement? Don't they provide the underlying document that is their basis for making the statements, that the reasonable reader could go look at that underlying document and make their own assessment as to whether or not that's a correct statement or not?
I don't think they do. What they do is, in fact, the fact that these tweets are paired to very brief descriptions of financial metrics. For example, One of the tweets says, Arrow's increase in trade and other receivables, use 72 million in cash despite sales decline, fraudulent sales being booked and not collected. In fact, I believe that the fact that they're using financial metrics and then coming to the conclusion, the factual assertion that fraudulent sales are being booked and not collected, I believe that these are financial metrics that are being marshaled in order to try and convey to the reader of these statements that seeking out that the Mangrove Partners knows that these sales are fraud, and we are going to show how sophisticated we are by picking out particular metrics from this earnings call to which these related that may escape a lay investor. And
so you're saying that the statements that follow explaining, for example, the statement about the $58.5 million in receivables that follows the statement about the fraudulent revenues, that's just not complete, significant enough, and enough of the statement? Doesn't the party have the ability to look at all of the statement? I mean, isn't that what's stated enough to show that there's a factual basis to that?
I think 2 points, Your Honor. First, what Davis tells us to do is actually look at the statement itself, fraudulent revenues. And we need to look first to see whether this carries a precise term reasonably understood to be proven false or not. Whether Eros has engaged in fraud and the revenues are fraudulent is something that can be proven true or false. I would then say that the fact that these are statements after statements, mutually reinforcing the assertion that Eros is engaged in a fraud and just putting all the numbers they can to support that, makes this look a lot like the Enigma case.
So it's your burden to demonstrate. Do you have the remainder of the section that suggests that what they've said is not true or is inaccurate in some way?
Your Honor, our position is that the mere fact that they are accusing
not what they tweet, but what the factual basis that they follow that follows after the tweet.
We believe that the tweets themselves, the complete fraud, the fraudulent sales, those alone are statements of fact under the test articulated by Davis and also as implemented by the court in Enigma. And that to the extent that these factual assertions are being bolstered by the inclusion of factual metrics, that only lends to the reader to think that these folks are sophisticated and they know why Eros is engaged in a complete fraud.
Any questions by the panel? Okay, you have rebuttal, counsel.
Thank you.
Mr. Sorkin?
Good afternoon, Your Honors. May it please the court, Joseph Sorkin on behalf of the Mangrove respondents. Your Honor, I'm also joined today by counsel for the GeoInvesting, Clarity Spring, and Knight respondents to the extent any of the justices have a specific question for them, but I will handle and respond to Mr. Albert. Your Honor, let me start by saying that this litigation is an attempt by a public company to silence its critics. That's all this is, and nothing that Mr. Albert just said changes that fact. Respondents, as well as other analysts, have noted significant concerns about Eros's financial health for years. And what Mangrove did, as well as the other respondents, throughout its opinions was cite facts and point to financial information on which it based opinions. And each of those communications, including the tweets that Mr. Albert just talked about, is constitutionally protected opinion. And Your Honors, this isn't a close call. And that is exactly what happened when Justice Cohen looked at the tweets themselves as well as the reports. Your Honors, I want to, I guess, start with 2 points that I plan to address today. First, the context of the communications, and we'll look specifically at the Mangrove tweets, leaves no doubt that they are pure opinion and not fact. And second, the Court of Appeals and the First Department have laid out a well-established framework for determining whether a statement is actionable. And Justice Cohen applied that framework to the statements at issue and quite simply got it right. I'm going to start just on the second point for a minute. Mr. Albert suggested that Davis was somehow a sea change in the way that the Court of Appeals and the First Department should look at and analyze a motion to dismiss in connection with the defamation claim. It was not. All Davis did was apply the well-settled law that has been established by New York courts, by the Court of Appeals in the 80s and 90s, and by this court and the trial courts since then in cases like Silvercorp, in which Justice Ed Mead in 2012 determined that even though there were statements about fraud, the question is, what's the larger context? Yes, the plaintiff gets the benefit of the doubt at the motion to dismiss stage, but that does not negate the constitutional defense regarding opinion that the respondents have. Similarly, it is no different than Justice Kern's opinion that she authored in Nanoviricides in 2014. Again, short sellers, that was a situation where a plaintiff was attempting to get information. Nothing about Davis changed the standard. The question is whether a reasonable person could look at the information in its context and determine that it was anything other than opinion. And Your Honor, that's exactly what Justice Cohen did here. He looked at the context and determined that the only reasonable reading was with respect to opinions. He first looked at the articles and reports. And Justice Renwick, you talked about what were there here. They were categorized two different kinds of communications, articles and reports, which Justice Cohen looked at and determined in their context, they disclosed the underlying facts. There was no dispute about the underlying facts, and this is critical, and I will come back to this on the tweets. No dispute about the underlying facts. That is dispositive here. In addition, the reports had language of conjecture. I believe, this is my opinion, that made clear that this was opinion. And the reports were posted on online forums like Seeking Alpha that generally trafficked in sharing financial opinions of this type. Now, let's look at the tweets. In addition, Justice Cohen looked at tweets. He first said the tweets that simply circulated those reports, those are no different, rightfully so, and he put those to the side. Then he looked at the tweets that Mr. Albert has talked about. The suggestion from Mr. Albert that Justice Cohen did not consider the tweets at issue, the tweets that Eros has identified on appeal, is simply not true. It's not credible. If you look at there were two arguments, first on the original complaint, then on the amended complaint. There were two transcripts. In addition, there was complete briefing and the complete complaint that was submitted. All of that was submitted and read and shown to be read in the decision and order issued by Justice Cohen. The court below considered all of the written opinions, and the suggestion now that somehow the respondents pulled one over on the trial court through two oral arguments, through all the briefing, through all the submissions, is just simply not true. That is not what happened. What the court did was say, I'm going to look at examples, because there were over 100 tweets that were at issue in the complaint. The court looked at examples, as was completely appropriate to do, and said the tweets follow a pattern. They provide a statement of fact and then give an opinion. That was shown in the examples. And now if you look at, and again, I implore the court to look at A422 and A423, the actual record, because it is not enough to look at the one tweet. It is critical, as the Court of Appeals has established, that it's not only the context of the tweet, but the context of the larger platform and set of communications that the court has to understand. So, July 28th, 2017, Alpha Exposure. Tweeting under the pseudonym Alpha Exposure, the Mangrove defendants, as alleged, said, let's be clear. Today's Eros results should prove that the company is a fraud. There's no doubt any longer. Now, again, context is important. It is not one tweet. There are then a series of 28 tweets that were put out as the earnings call for Eros was being published, was being put out, meaning that the earnings report went out in the morning, and then there were questions by analysts. As that was happening, the tweets are responding. The next one says,
I think we understand how that worked. Are there any other questions from the panel? Thank you.
Thank you.
Mr. Elbert, we're back to you. You have 2 minutes.
Thank you, Your Honor. With respect to the tweets that we were just talking about, I think it's important to note that there is a lot of space between the facts that are disclosed and the allegations of fraud. And again, Your Honor, if you look at our briefs, I do believe that calling Eros a fraud is independently actionable as a factual assertion. But even if we look at the financial data to which these allegations are compared, what we have here is a giant gulf that an ordinary layperson is not going to understand. They are taking financial metrics that are disclosed as a matter of fact and then saying that these indicate fraudulent sales being booked and not collected. And this leaves a reader to believe that these sophisticated folks who are tweeting know something more, that there are implied facts that I don't have access to that allow them to have the jump from the allegation of fraudulent statements to just the mundane financial information. And one more thing that I would say, Your Honor, is that with respect to the articles that were considered by the judge below, an important point is that facts, the disclosure of facts, is not a complete insulation to defamation claims. If you look at, in particular, the geo-investing articles, what we had here were facts that had nearly nothing to do with the conclusions that the defamers were asking the readers to draw. By way of example, in the first one on March 8th, what the defendant said was, we have concrete proof that Eros is engaged in a fraud, and we've uncovered stunning evidence. And when you actually look at what the evidence is, anonymous allegations from a lawsuit that was filed almost a year before that. These are distorted facts in order to render in the reader's mind the idea that Eros is engaged in fraudulent enterprises.
Thank you.
That's my time.
Thank you both, Mr. Sorkin. Thank you as well. One West versus Cassandra Fox.
Good afternoon, Your Honors. Greg Verrilli for the appellant, and may it please the court. It's appellant's contention that the Supreme Court abused its discretion by rejecting counsel's explanation of law office failure and dismissing this action instead of granting an adjournment or continuance of the trial. The Supreme Court refused to consider counsel's reasonable.
So I have a question. This is Judge Owen.
Yes,
I mean, you knew ahead of time that you were going to have a little bit of a problem, correct?
Yes, Your Honor. I mean, we knew.
How long before the trial date that you knew you were going to have a little bit of a problem in terms of witnesses, that you needed 2 more witnesses?
Yes, Your Honor. So in the record, Mr. Mottola, who was the attorney that appeared for Ras Boriskin, he detailed that basically he was the trial attorney that was assigned to this matter.
You didn't answer my question. You're making a long answer to a question that how long or how much of a early before the trial date did you know you needed 2 more witnesses? Yes. It's a simple 1 week, 2 weeks, 2 days, 24 hours.
Mr. Mottola said about a week prior.
Okay, so that my question then is, you know, and I read the transcript here. Supreme Court, she's a guardian part, so they were all backed up. So she they wanted her to try this case. So she gave you a day to try this case. I mean, everybody knew that this was not a typical case that's tried in the guardian part. So did anybody even think about calling the judge or at least the law clerk and say, by the way, Judge, we got a problem?
Yes, I believe that.
Yes or no?
Yeah, I believe that the transcript reflects that there was contact made with the court to advise her ahead of time that there was an issue with the witnesses.
Okay, so how long, apparently that may not have been the case that it got to the judge, though.
I believe it did. Unfortunately, this record is not as complete as we had hoped. But
so you know what I've learned in my practice when I was in trial practice is that you need to have at least you need to have a paper trail of some sort, right, to protect yourself.
Yes. So there's
you know, you sandbag the other side, and now you want to put it over another time. You know, you want to put the case over again. I mean, and you had this case for how long? How long was this? Was in 2010. This case was started, correct?
Correct.
And then it was brought to trial. Now we're looking at, I'm looking at my notes here. We're looking at a case that's being ready for trial December 2019, 9 years later.
Correct, Your Honor. But
at some point, you gotta come on, you gotta fish or cut bait, right?
Unfortunately, Your Honor, the full procedural.
Well, not unfortunate for me. Unfortunate for you.
Well, yes. No, it's unfortunate for because of the way that this matter went to trial and because it was just on the record. We don't have the full procedural history in this record.
All I know is that you saw the judge, right? Judge Rosado. She picked a date. She asked everybody, how many witnesses you got? Your attorney, and by the way, your attorney your attorney that showed up or appeared before Judge Rosado doesn't even put in an affirmation explaining what happened. You're just throwing her under the bus. From what I look at the record, you throw her under the bus, saying she should have known better and she messed up. And and the attorney that showed up saying, I'm the supervisor for these. I don't mean to give you a hard time, but this is the record that's in front of me, saying I'm the supervisor of these trials, and she messed up. Well, okay, that's fine, but it's the way I understand it is you're in the judge's house, so you got to abide by the judge's rules. It's her rules. It's like, you invite someone to your house, you expect that person to be a very good guest, right? You're not going to tear up the person's place. And she said, one witness, and then the defendant says, I don't need a witness, Judge. I'm done. I'm not calling any witnesses. So, there's frustration on her part saying, come on, this case is 9 years old.
Yes, Your Honor. But respectfully, that's the issue that we have with the lower court's decision is essentially she just made a blanket statement that because this case has been pending
it wasn't a blanket statement. It was more of a enough is enough. I told you guys, and that's the end of it.
I respectfully disagree, Your Honor. There's nothing in the record.
Okay, well, we have to see, follow what's in the record. You have a minute rebuttal. Mr. Marquez?
Yes, if it pleases the court, can you hear me?
Yes.
Okay. I think Justice Erling characterized everything perfectly. First of all, it was 9 years in the coming. Multiple motions for summary judgment were done. Years of delayed discovery. Then we get to the point where the court is saying, okay, it's 9 years later, we need to expedite and get rid of this case. And when we go there in October, yes, they knew if they had lost 2 motions for summary judgment, they knew at that point what witnesses they would need in order to make it a prima facie case. And they were not prepared when it came to the pretrial conference to say the number of witnesses that they actually needed. But that should have been known.
Well, I guess, Counselor, this is Judge Roy. Well, I guess what they should have done was they should have covered themselves and say, I need 5 witnesses, just for the sake of saying 5 witnesses. And if you come under 5 witnesses, you only show up with 3, you're good to go, right? Instead of saying, I only need 1 witness, right?
At the very least, they sent somebody to court with a pretrial who did not know the case, did not have the power to bind them in a way of resolving issues, but rather just went there.
Okay, I have a question to ask you. Did anybody reach out to you and tell you this was going to be a problem before the trial date?
No, sir. What?
You think so?
It was at the last minute, sir. They arrive at court, say, "Oh, we need an adjournment. We need a continuance."
And you're sitting there thinking, 9 years later, you want another 9 years to go for this case? Well, goodness sakes, my grandkids are going to try this case.
Exactly, sir. And I was there with my client, ready to proceed after 9 years of litigation.
Yeah. Thank you. Let's go back to Mr. Verley.
Thank you, Your Honors. I just have to say,
Counsel, I have to say one thing.
Yes.
And, when I read this record, the one thing that your attorney didn't do was fall on their sword. They did a lot of pushback to the judge, and they didn't fall on their sword. Sometimes falling on the sword may be a mortal wound, but I tell you, sometimes that might help. But when I read this record, it was kind of a pushback against the judge, and I don't know.
I don't think that's what he was trying to do. I think he was just trying to explain the process by which.
Yeah, that's the sense I got from the record, though.
Well,
Okay.
Your Honor, if you will, I can just make a couple of points very quickly. I think what the attorney was trying to do was to explain why, how things are entered into the computer system and why there was an issue and why there was law office failure. And quite frankly, I believe that the record does.
Counsel, I don't mean to
reflect
be
that there-
glib. I don't mean to be glib, but when I have to explain, my mother has a saying. She says to me, if you have to explain yourself, forget it. You're lost.
Well, if there wasn't anything in the record about what the process was about, how the issue came about, then Your Honors might say, well, there's not enough in the record to say that there was a reasonable excuse and that it was just they had no support to it. I think that's what the attorney was trying to do. And as I noted previously, there is the testimony in the record that he did submit something to this court previously. And as I pointed out in my reply, that would have been shared with counsel. I don't know why he's saying that.
Well, we don't see it. I don't see that in the record. But anyway, thank you
on
very much.
record page 9. He said, I submitted something in accordance with the rules. And so that would have been ahead of time. He explained that this came about.
I guess what I meant was that something didn't seem to be before the judge. Thank you very much. Thank you both.
Thank you. Have a good day, Your Honors.
Thank you too. Harris versus Israel. Okay, Mr. Emke. Yes,
Thank you, Your Honor.
you're welcome.
Good afternoon, Your Honors. May it please the court. Petitioner appeals from a decision of the appellate term, which improperly applied the Housing Stability and Tenant Protection Act retroactively in order to vacate the judgment of the civil court. That overbroad reading of Part I of the HSTPA is inconsistent with substantial case law, recognizing that retroactive application of the law implicates fundamental issues of fairness and must be viewed with great suspicion. The appellate term disregarded when it applied the HSTPA to this case, and its judgment should be overturned on either of two independent bases. First, there is no evidence that the legislature intended Part I of the HSTPA to apply to occupants like respondent whose tenancies were terminated before the law was enacted. And second, even if the legislature intended that outcome would constitute a violation of petitioner's due process rights. Looking to that first issue of the legislature's intent.
The strongest argument, Counselor, the Regina case. I mean, isn't that really your only argument?
Your Honor, I don't believe that the current case relies on Regina Metropolitan or that it's in or that it's in any way dispositive of this case.
Really?
I believe that Regina Metropolitan provides a clear path for analyzing.
Are you telling me that we do not have to apply the Regina case to the facts in this matter?
Oh, I very much want you to apply the Regina case to the facts of this matter. I'm saying that this case does not rely on Regina Metropolitan and that this court.
You want us to rely on the statutory language of the new statute?
And as well as the Regina Metropolitan case, the only distinction
I mean, which one do you want to rely on? You got to make a choice.
So if we analyze this under the Regina Metropolitan case and the contrast that it drew between the effective date provisions of the various parts that constitute the HSTPA, I do believe that the Court of Appeals ruling is relatively definitive in this case.
Relatively definitive.
The Court of Appeals and
give me a new light on this Regina case.
The Regina case held that the HSTPA is almost entirely forward-looking, contrasting that with the retroactive application that was recognized in Part F. The court specifically recognized that while Part F explicitly applied to pending cases, the rest of the HSTPA was meant to apply only on a forward-looking basis. 11 of the 15 parts that constitute the HSTPA take effect immediately, just like Part I in this case. So when the Court of Appeals in Regina Metropolitan was drawing a contrast between Part F and the rest of the statute that it thought applied only prospectively, Part I was a part of that. And so I do believe that Regina Metropolitan does decide this case, but I think that there are other bases upon which the court can rule in petitioner's favor today.
Thank you. I'm sorry.
Stephen Sperber, Your Honor.
Mr. Sperber.
May it please the court, my name is Stephen Sperber and I represent Regina Israel, the 30-year occupant of this rent-regulated apartment. The language of the statute is quite clear.
Excuse me, Counselor.
Why isn't Regina controlling? I know he didn't want to, your opposing counsel didn't want to say it, but why isn't Regina controlling in this matter in terms of finding that a retroactive application of it would be unconstitutional under these circumstances?
I would suggest for 3 reasons, Your Honor. First and foremost, if you look at the Regina analysis, there's 3 different things that they look at. Does it impair a right that somebody was possessed with? Yes, it does. Does it impose new duties? Yes, it does. But does it impose liability for past conduct? And that's the distinction. The reason that Regina knocked out Section F is because it imposed new financial liability, which the other side would be unprepared for. And you have to
new financial liability. Didn't the owner of the property in this case put in a substantial amount of preparation, funds, and reliance on the old law to create the combination of these 2 houses? Wasn't that the only reason he purchased the property, and reliance on the law that allowed him to do that? So why wouldn't that be an expenditure of substantial funds?
Because, Judge, you have to look at what the intent of the statute was. It was intended to preserve the housing stock and protect elderly long-term tenants.
That's absolutely true. That's absolutely true, the purpose of the statute when it is applied, but this is a question about the retroactivity aspect of it that Regina seems to speak to.
What could they possibly have meant, the legislature, when they said, quote, "It takes effect immediately and applies to any tenant in possession"? And it takes me back, Your Honors, if you just allow me, it takes me back 32 years ago to the case of McMurray.
Counsel, there's a question.
I'm sorry.
How old is your client?
How old is my client? In her 50s. She's lived there for 30 years.
How old is she? I'm sorry?
She's in her 50s.
Okay, thank you.
It is my guesstimate. I don't want to say that she's a senior because she still works. The record is bare on that point.
Well, I still work. I'm past. Well, that's not that doesn't tell you anything.
Justice Kern, I didn't hear you.
That's because you keep talking. Isn't the point of Regina that even if the statute uses the words on its face that might suggest retroactivity, that would be unconstitutional in certain circumstances? But in your arguing the language of the statute, the whole point of Regina is that we're not just going to rely on the language of the statute because the statute is applied is potentially unconstitutional.
Your Honor, what I would also like to say is that it's not the first time the rules have changed on owner occupancy. In fact, it was 35 years ago that I was a young attorney who represented a person named George Wild, who tried to evict a person.
That's not answering my question now. I mean, I know you want to say that, but you're not answering the question that I asked.
Well, I know it's not unconstitutional, Your Honor, not in the least, because it has an intent, it has clear language, and this is within the class of people that is intended to be protected. And it doesn't create any new financial burdens. And when you purchase in New York City housing, you know you're in an area that's highly regulated, that the rules do change from time to time. And this happened in '84 with owner use. It happened in '87 with succession. And in our brief, we cite to many cases in many parts of the rent stabilization law that have changed over time.
But you would be right about those cases that change over time. But this one, Regina, is now the case of this time. If it didn't exist right now, we might have come up with a different result, or might. And I'm not saying we've decided, but if you're looking at the application of Regina, we have to determine whether that is applicable right now.
Well, again, Your Honor, I would then go back.
Well, I don't want you to go again because we heard what you said. So unless you have something new, thank you.
No, that's all, Judge.
And you have 2 minutes, Mr. Emke.
Thank you, Your Honor. The only point that I would want to address is the distinction that opposing counsel was drawing about the idea that Part F at issue in Regina Metropolitan created a new financial burden, and that is, according to opposing counsel, not at issue here. The difficulty is that what opposing counsel is focusing on are the circumstances that trigger the presumption against retroactivity in the first place. Opposing counsel didn't argue that in his brief, and more importantly, the retroactive effect is abundant here insofar as Part I does, as Your Honors recognized, impair prior rights that petitioner had prior to the enactment of the HSTPA, in addition to imposing the new duties that respondent now seeks to impose upon him. So just with that distinction.
Thank you.
Thank you.
Thank you both. Thank you, Mr. Sperber. Medina versus Shea.
Michael Confucione, Your Honors, for the appellant, Officer Medina. I rely on the briefs we submitted. I think it really comes down to a question of what we submit as an error of law in applying New York governing law on causation. Essentially, in the Article 78 determination, the Supreme Court upheld the board's determination that the surgery was the cause of the disability in the case, not the February 2015 van accident. The error of law that we contend was made was that the originating accident from February 2015 was still a proximate cause of the ultimate disability that occurred from the surgery. And if you look under even just general New York law of proximate causation, generally you look at whether or not something was a substantial factor. Even under that type of analysis, the van accident, which initiated and originated in the problems, caused her to walk with a cane. It's important she never returned to full-time duty. She was always on restricted duty, walked with a cane, tried conservative treatment for a number of years, and ultimately was rendered disabled, unfortunately, from a surgery that, although it was designed to improve her condition, ultimately it made it a lot worse. But that does not remove the February 2015 incident from being a cause. It doesn't have to be the sole cause, but it is a cause. Unless the court has any questions, that's really the crux of the argument in the appeal.
Thank you.
Thank you, Your Honors.
Paulson?
Good
Ms.
afternoon,
Paulson?
Your Honors. May it please the court, on behalf of the Police Pension Fund. Your Honors, the Supreme Court properly affirmed the Police Pension Fund's determination to award ordinary disability retirement where there was ample credible evidence to support a finding that her disability was not caused by the line of duty incident. The flaw in appellant's argument here is that Ms. Medina was not found disabled after the line of duty incident. So the surgery didn't break. It was not a causal factor in her disability. If you look at the records, Ms. Medina unfortunately suffered from a history of low back pain. As early as 2008, if you look in the record at page 462, she was diagnosed with lumbosacral spine disease. She had a progressive back condition. And when she had the line of duty incident in 2015, the records show that she sustained no acute injury on that date. She had no fractures. She was recommended to go back to work, which she did. Her rehab potential for the following 2 years was considered to be good. And none of her doctors in the 2 years following that line of duty incident opined that she was disabled. When she went before the medical board the first time prior to her surgery, they found that she was not disabled. She then had surgery and went back before the medical board again. After her surgery, there was a disability finding. Before the surgery, she was able to walk with a cane, to sit at 90 degrees, to do leg raises without radiating pain. And she was continuing to work in the crime scene unit of the police department in this restricted duty assignment. Because she had been in that assignment for 2 years by the time she applied for disability retirement benefits, that was the operative assignment for the medical board to determine if she could still continue to perform. It was not until after her surgery that she was so uncomfortable, in her own words, she was completely disabled, that she could no longer walk unaided and sit at a desk comfortably and perform that. Your Honor, after the surgery, her complaints were worse. The medical board couldn't even fully examine her. It was at that point that they found she was disabled, but they could not find a causal connection to the line of duty incident. Just briefly, after the finding of disability, she went back to the med board for a third time with no additional medical records, but in order to consider the argument of her counsel about aggravation, to determine that. And again, the medical board found no causal connection. By a tie vote, the police pension forum affirmed it, and Medina cannot establish causation as a matter of law, which is what she needs to do in order to overturn a tie vote of the police pension fund. For these reasons, the decision of the Supreme Court should be affirmed. Thank you, Your Honors.
Thank you both. Thank you, Mr. Confucione. Thank you as well. Okay.
Thank you, Your Honors.
Cutler versus 979 Corporation.
Yes. Good afternoon, Your Honors. My name is Scott Mullen, and I thank you in advance for your patience, realizing how many cases you've heard already.
We're used to it. It's okay, but we appreciate your gratitude.
Getting right to what I think is the heart of the matter is this was brought as an Article 78 proceeding. And if it's brought as an Article 78 proceeding, then the burden is on the other side to show that the co-op board acted in an arbitrary and capricious way and in bad faith. It was their burden. And therefore, if it's their burden in an Article 78 proceeding, if the board had one single reason, just one, that constituted a reasonable basis, then the ruling determination of the board should be upheld. In this particular case, the board didn't have one particular reason. It had several that would put a board fiscally prudent on concern. This was a building, bear in mind, that only had 8 units.
So this is Judge Kern. Under the heightened standard, which clearly applies to this case, because you have to not unreasonably withhold consent, isn't the only reason you could withhold consent is if she was financially unable? And how can you show in this record that financially irresponsible? How could you show that she was not financially responsible based on the substantial assets that she had?
Okay, the direct answer, I have 2 answers to your question, Your Honor. One is that I don't believe that it was limited to financial. I believe, for instance, by way of example, if there was evidence that somebody had engaged in illegal activities in an apartment, that could be taken into account by the board. What the lease said, paragraph 6 of the lease said, was consent cannot be unreasonably held. And it also said that we have to focus on the financial responsibility.
Counsel, was there anything in this case other than financial responsibility, the lack thereof, that was a basis for the denial?
No, in this particular case, I think it was a combination of the financial lack of financial information that was necessary to make a reasonable decision, coupled with the fact that the board seemed to have to, in essence, pull it out of the applicant on a rolling basis rather than a forthcoming presentation. And the reason I'm going to be specific, for instance, there was no evidence provided as to the terms of the trust. When they finally, and bear in mind, the annual income reported was $15,000 annual. The maintenance here was $15,000 to $20,000 per month. There was evidence that there was money in a bank account with no explanation. People, I think it's common knowledge that lenders ask when they see a deposit in a bank account and they're considering a mortgage. Was it a gift? Was it a loan? What was the source of the funds? And there's no evidence of that. So in this particular case, the trust agreement was not provided. They finally provide the trust agreement, and what does it say? The trust agreement says the trustees have absolute discretion. So the trustees have the right not to provide funds. And families get into fights, they get into disputes. In fact, in the Trump case, Trump family, there was a litigation over cutting off medical expenses. Somebody in the family cut off medical expenses because of a family dispute. So there was absolute discretion in the trust agreement. So the simple answer, the simple remedy in this situation, which is a frequent problem, by the way, to deal with, is you have the trust come up and provide a guarantee of the maintenance when you have somebody with inadequate financial evidence. And in fact, if I might point out, my adversary, Mr. Berkey, who has a long distinguished record in this field, had basically written an article that said how can we assist shareholders when they're not fiscally strong? And his answer was the solution, and these are his words, the solution is to obtain a third-party guarantee. And he went on to say,
she's not financially strong when she's the sole beneficiary of an extremely substantial trust. Although there is some discretion, the trustees have to act reasonably. And how could they reasonably withhold allowing the maintenance to be paid in her apartment when she's the sole beneficiary of such a substantial amount of money? How could that possibly be?
In this, yes, the direct answer to your question, that question, is that this particular trust agreement did not provide that the trustees have to act reasonably, and just the opposite, gave them absolute discretion. And apparently, for some reason, and I can't speak for the family, why it was set up this way, but we've seen trust agreements where the beneficiary gets the money at 25 years old, at 30 years old, at 35 years old. If you look at 466 or 467 of the record, this trust was supposed to last until the person was 70 years old. I don't know why the family set it up that way, but there is absolutely no comfort that they can have that there's an agreement between the trust and the co-op. And in fact, what they did then is come forward with affidavits. The judge on an Article 78 is supposed to look at the record as it existed at the time of the decision in February 21, 2019. The judge kept wanting to do this on a rolling basis and forcing the board, putting itself in the position of the board by requiring them to look at other evidence that wasn't in the record. And they come forward with an affidavit that says, the trustee says, I intend to ensure that the expenses will be met. Would any one of the judges on this panel ever sell their home pursuant to an agreement that said the buyer intended to ensure the sale would go through? That's wishy-washy language coming from very sophisticated people. So what happened afterwards when that was pointed out and that was rejected? Then they came forward with a purported agreement that wasn't provided until a year after the rejection in February, approximately a year. And that agreement didn't make the co-op a party to it. They said the co-op will be a third-party beneficiary. It didn't say that the trustees can't have set-offs and counterclaims. And if there's a fight between the trustee and the beneficiary, how would the co-op enforce its right? My adversary pointed out, co-ops deal with guarantees. Where in this whole record, very lengthy record, where is there a simple guarantee by the trust of the maintenance obligations? It was never offered. That was a strategic decision made by the other side. I can't explain why they didn't simply do that. That's done all the time.
Thank you, counsel. I've given you a little extra time. Mr. Berkey?
Thank you. Good afternoon, Your Honors. May it please the court, David Berkey, Galadrier and Berkey, for petitioner Stuart Kotler, who's a respondent and cross-appellant. Justice Kern hit it right on the head. The Del Terzo standards.
Counsel, this is Judge Drawing. I got a real question. I got a simple question. Why does your client want to move into this apartment building when they don't want her? I mean, it's just like she's, you know, is she going to be happy in this apartment? It seems like the board doesn't like her. I don't know why, but is there something she wants?
Your Honor, there's one board member who has a long history of a dispute with Ms. Hames' father.
Okay.
That's the person who's leading the board. Everyone else is friendly to her. The Tishas, other very well-respected people.
That was a concern I was having, like she's running into like a fire here. Okay, got it.
That's correct.
Thank you.
Let me go back to what I was saying. Okay,
the estate of Del Terzo. I had to know. Thank you. Okay, got it.
Okay, again, Justice Kern picked the right standard. Del Terzo, as espoused by this court and affirmed by the Court of Appeals, applies here. Only 3 weeks ago in Alcott, Justice Mazzarelli was on the panel that again reaffirmed the Del Terzo standard. And what is it? It's a heightened standard of reasonableness. We started off giving the board the financial information that proved that our client was financially responsible. She had 15 times the annual maintenance in liquid assets in her bank accounts. She was the beneficiary.
Did they ask you to demonstrate where that money came from?
They were told it was saved from distributions from the estates, Your Honor, from the trusts that she got, distributions from the trusts. And they were told that the trusts were
They did ask, and you responded.
Yes, and they were going to get she was going to receive $550,000 a year in 2017, 2018, which by the time this case was argued, went up to over $900,000 in distributions from the trusts. And contrary to Mr. Mullen's statements to the lower court and to this court, if you look at the record at pages 445, at pages 537, at page 390, you will see the trust agreements require at least annually that the trustees distribute the income to the trust beneficiary. The discretion that they have is to distribute that income more frequently than annually, but that's it. The other discretion they have is to invade principle, which is absolutely unnecessary here. But as Mr. Mullen rightly said in their affidavits and in their agreements, they said if we have to, we, of course, will invade principle for the benefit of Ms. Hames. And, Your Honor, there is nothing factual that shows she can't pay. There is no history of any kind of failure financially. She has no debts. There is nothing that's claimed against her. And as Mr. Mullen said, you know, when the board tried to impugn her by saying she was engaged in some kind of misbehavior with the estate, Justice Rackhauer said that is a vengeful, vindictive statement that this board is saying. This is on the record at page 14. There is no way they should be raising any of those claims with respect to Starr, and she was upset with the behavior of this board, and rightly so. The issues that the board raised were bogus. There was no fraud. We showed the Internal Revenue Service own examiner coming up with a value for the apartment at $6.9 million and settling with the estate.
Counsel, I have a question. This is Judge Owen. I have a question. You know, in terms of all these these alleged tax liabilities and whatever liens that may happen, how's that going to harm the building? It's actually your client that's going to be on the hook for all this, right? I mean, if anything, it's the apartment that's going to be grabbed back and not the bill. I mean, I don't see where, unless I'm missing something, where is it in the sense that there's exposure to the building or the co-op board?
You know, Justice Wong, the record at page 228 shows the values in the estate, over $15 million after the taxes were paid, $6 million of which were liquid. So if the federal government or the state government came back to the estate and said, pay us some more taxes, it's sitting there, it's available. There's no lien threat that's realistic. This was all bogus on behalf of the board. It was shocking to me that they would come up with the misrepresentations of the trust, this insinuation of improper behavior.
Well, you have a cross appeal, sir?
Yes. Let me spend a couple of moments on that, please. The cross appeal deals with a mistake that Justice Rackhauer made at page 44 of the record, when she said essentially that the estate is willing to pay the carrying costs of the apartment, so the estate shouldn't be damaged. Well, Your Honors, it was only the trustees.
You're talking about the flip tax, right? Are you talking about the
No,
flip
I'm
tax?
talking about damages that we had asked Justice Rackhauer to award, which are the monthly maintenance payments that the co-op has been receiving and benefiting from, despite the fact that since the 21st of February 2019, they don't allow anyone to live in that apartment. Those are real damages, and the estate is suffering those damages. And the estate has more beneficiaries than just my client. Her brother Evan is also a beneficiary of the estate. So it's unfair for the estate to be saddled with these damages. And Your Honors, in many cases, the Arlew Associates case, which is in our brief, deals with what the damage remedy is for an improper denial of an assignment. And that's the money that's paid to the landlord after he's improperly refused an assignment. And that was reaffirmed last year by this court in the WG3 case, which we cite in our brief in 2020. So
you're asking to have this remanded, though, to calculate what your damages are in the event you're successful. That's the relief you're actually seeking, right?
That is correct, Your Honor. And the court below has the power to do it. The CPLR section 7806 dealing with judgments allows the court below to award incidental damages to the relief that is awarded. And it also allows the court to direct or prohibit certain behavior. So with respect to the flip tax, the judge rightfully prohibited the board from collecting a flip tax in connection with this transfer. And with respect to our request for damages, because the estate is damaged and it's only incidental to the relief that we were seeking, the court below should be awarding damages to us.
Thank you. Back to you, Mr. Mullen.
Yes, first of all, let me do it in order. Del Terzo had a fact pattern where a co-applicant had clearly demonstrated financial capability to meet the expenses. And that was the holding. Although it was a 3-2 decision, the majority relied on the fact that the co-applicant had a strong financial statement. With respect to the Alcott case, which I know Justice Mazzarelli remembers because it was so recent, Alcott made a point out of saying that even if the lower amount of the alleged income were accurate, there was plenty of money and that was a sufficient number to meet the expenses. So in both cases, Del Terzo and Alcott both required a demonstration of the income. As I said, in this particular case, there is no guarantee by the trust, which is a very common way of dealing with this kind of situation. With respect to damages, we go back to the petition. Again, the procedural aspect of this cannot be ignored. This was an Article 78 proceeding. It was not a hybrid proceeding. There is no claim for all the cases they've cited, included claims for either breach of contract, interference with contract. Not this case. This is strictly a petition for Article 78 relief, and there's no claim for damages in there. So that is why the decision should be upheld with respect to the damages. Again, I think the board has a right to ask for a guarantee when somebody shows $15,000 of annual income. That's all they showed. And I don't think the First Department should say that's unreasonable for a board to ask for the evidence, to reject an affidavit. Don't forget, the agreement that was proffered didn't come until a year afterwards. The affidavit said, we intend to ensure. You can't have this loose language when it comes to dealing with co-ops. It just undermines the law, which is, unless it's a statutorily prohibited ground, the co-op has a fiduciary duty to protect the shareholders. And here, there were legitimate questions that were asked. The court below, and even this court, may come to a different conclusion. That doesn't mean that the board didn't have at least one reason that constituted a reasonable reason. I think they had multiple reasons. Thank you for your patience.
Thank you. Thank you, Mr. Mullen and Mr. Berkey.
Your Honor, I've got reserved time for—
Oh, I'm sorry, you did. I'm sorry.
So if I may just address two things. First, in our petition, we specifically ask for damages incurred by the estate due to the board's refusal to approve the requested transfer. That's in the record at page 54. Second, with respect to Del Terzo, the amount of money that the non-resident brother had paled in comparison, not close to the amount of money and the annual income that is received by Star Hames. So, Your Honors, with respect to she being financially responsible, she meets every single test in the book. I appreciate your time, Your Honors.
Thank you. Again, thank you both.
Thank you.
Disler versus Biggs.
Good afternoon, Your Honors. May it please the court, Diana Lawless on behalf of the city appellants. With my minimum time here, I'd like to focus on why the city is entitled to summary judgment on the negligent maintenance claim. The city's duty here was to keep the road in a reasonably safe condition for travel. And as Your Honors know, municipalities cannot remove all snow and ice from their streets.
Isn't there a question of fact here, since you have a limited amount of time, I'll get right to it. Isn't there a question of fact here, given that they have an expert who said, given the temperature and everything else, there wouldn't have been slush, given the hours and the time and when the snow stopped coming down? Didn't people also say that they saw slush but no sand, even though the workers who were employed to, it was their job to put the sand down, said yes, they came back by 3 times, they came back by 4 times, but they were estimating. But based on the expert testimony, isn't that sufficient to raise an issue of fact here?
No, Your Honor. First, I'll start with the expert meteorologist. I think this is the type of expert meteorologist report that this court, in cases like Rivas, has found does not even meet the threshold for reliability. He didn't explain anything about the science behind it. He didn't explain anything about when it would have formed, how it would have formed. It was just conclusory. And he also assumed that all the city's records were false. He didn't say, he said the city must not have done anything. The city's official record said that it did things. And as for the eyewitness testimony, that was insufficient because they just were there at the time of the accident. So showing that there was, and this was black ice, a very difficult to see condition by its nature. Just showing that it was there at the time of the accident was not enough to show that the city had constructive notice of this condition at the time that the accident happened and needed to have time to remove it before it happened. And the plaintiffs seem to suggest that the city had to remove that all ice and snow, that ice and snow never could have formed at this location at any point during the storm, and that's just not what the standard is here. The city made a showing there was no triable issue of fact resulting.
Thank you. You have rebuttal. Ms. Korchanka, I think.
Good afternoon, Your Honors. May it please the court, Irina Kravchenko. I represent defendant Cabrera on this appeal. It is Mr. Cabrera's contention that the Supreme Court erred in denying him summary judgment because he simply, whether or not he was negligent, his actions were not proximate cause of the accident. The record is uncontroverted that the underlying incident involved 3 separate accidents, and the first accident in which Mr. Cabrera was involved was separated by both time and space from the second and third that involved plaintiffs. With respect to the time, while the testimony
in the record about why the drivers in the first accident didn't go off to the side of the road and stayed in the middle of the road after the accident occurred rather than pulling over to the shoulder.
Yes, Your Honor. With respect to that, it is Mr. Cabrera's contention that that's irrelevant. And I would like to cite legal precedent from this court, actually Renteria versus Simakov, which is 109 83rd 749 in 2013. And actually Justices Renwick and Mazzarelli were on that panel. It had a remarkably similar circumstances under which it held that irrespective of the location, the other accident merely presented the occasion for the occurrence of the second one, but did not proximately cause that. In the Renteria case, the cab driver testified that as he crested a hill.
How many cars were in that case that you just referred to? How many vehicles?
In the Renteria case, I believe that the cab driver was the third vehicle, and he encountered an accident of two other vehicles.
It was a hit in the rear type of case, wasn't it?
Yes,
with just
correct.
3 cars, not 15 cars or however many are here with cars all over the place. Anyway.
Your Honor, respectfully, it is Mr. Cabrera's position that the offense is still analogous to the extent that Mr. LeBron testified that, the first accident involving my client had something to do with this because when he crested the hill, he saw something nearby. But as this court held in Renteria, the operator has to maintain sufficient distance and speed to avoid the collisions under the circumstances they're existing. And particularly in this case, when we know that the weather was treacherous, it was extremely icy. And actually, and I'll quote from that case, the court specifically held that since the cab driver did not see the other incident 12 feet ahead, he was traveling too fast to maintain a safe distance from any cars stopped beyond the crest of the incline.
Thank you.
Exactly what happened.
Okay, thank you. Counsel for Suarez and Greenhouse?
Yes, Your Honor. Good afternoon. May it please the court. I don't want to take too much of your time.
I don't know if the background is coming from you or someone else, but anyone who's not speaking should have their mic off.
I do apologize. My son is 5.5 months old and he's making a little bit of noise.
Okay, now I hear a gentleman's voice. Go ahead.
Okay, so my position is very similar to that of my co-defendant Cabrera's. I do want to touch upon the argument regarding moving the vehicles to the shoulder rather than off of the highway. Whether or not my client should have moved her vehicle off the highway, it is our contention that that is irrelevant, because the fact that the plaintiff exited his vehicle on a highway where multiple cars were getting into accidents with each other was an intervening cause that was so far removed from the first accident that involved my client that she could not possibly be held to have caused the accident with the plaintiff. It was simply not foreseeable.
And finally, I think it is Sylvia Soto?
Yes, it is, Your Honor. Sylvia Soto from the Losses of Tremelo and Fishman. May it please the court and counsel, as I represent Ulysse Cabral, the appellant in this action. I will again concur with my colleagues that spoke before me. The basis for the lower court's decision that there remain questions of fact as to who was stopped, who had their hazard lights on, what cars were operable and weren't. In this particular case, the record is replete with testimony that Ulysse Cabral, the tractor trailer, had his hazard lights on, had his caution triangles out, was parked and stopped in the median yield zone. So when the court asked the question as to whether or not we were able to get off the road, that accident was 4 cars. And that accident occurred 45 minutes before the accident in question. That accident was approximately 250 feet away from the accident in question. The vehicles in that accident, in the 4-car accident, the first accident, was in the yield zone. All of the cars were in the zebra striping, and that's confirmed by the sanitation worker who came upon the scene from across the roadway, asking everyone to stay in their cars because the road was so slippery. Also, 2 of those vehicles were in contact. The tractor trailer and I believe it was Ms. Hernandez's vehicle were stuck together, but because of the collision. But both of those vehicles were in the yield zone, and it's shown in the photographs that are attached to the record, because there's several photographs attached to the record. These vehicles were in the yield zone. They were not in the roadway. Now, there is testimony that immediately before the accident, Mr. Biggs, who was involved in the 3-car accident, which involved Mr. Biggs, the van carrying Plaintiff Sosa and his sister, and also another van, Santiago. 2 vans, Mr. Biggs came upon those 2 vans, struck one of those vans. That accident was the second accident, and that accident was approximately 250 feet away from the first accident. Mr. LeBron then came upon that accident. And Mr. Biggs—
This is Judge, I'm sorry, Counsel,
Yes.
This is Judge Owing. I have a quick question.
Sure.
With regard to the first accident, the vehicles involved in the first accident, were they off to the side or were they still on the roadway?
They were in the zebra striping, in the yield zone.
Off to the side?
I'm sorry?
Off to the side?
That's correct. They were not in a lane of traffic. There were 2 lanes of traffic. There was 2 lanes of traffic. To the right of the 2 lanes was a yield zone.
What photograph in the record, what page in the record is the photograph that indicates it?
Your Honor, unfortunately, I haven't been back in the office, and the record, I don't have the record before me.
But the photos are in the record?
I believe so, yes.
Okay.
Where was the trailer truck?
The trailer truck was in the yield zone.
The zebra line you're talking about?
Yes, the
When
zebra
you
stripe.
say a yield zone, is that something that's the road is dividing and so it's not like it's on the side of the road, it's more or less in the center of the road.
Well, Your Honor, in that particular area, 2 roadways converge. So what's happening is 95 is converging with the other roadway. So there is a yield zone in the center. There is a yield zone in the center, and that's where those vehicles were. the accident that we are.
Counsel, when you're saying the two roads are merging, you're saying coming off the GW Bridge, where you have the upper roadway and the lower roadway, they're merging onto I-95? Is that what you're saying?
Yes,
No.
if you just can give me a second, I can tell you. Yes, it's exactly, hold on one second.
Okay.
It was southbound or northbound?
They were going northbound. So the road converges with road 95 and road 278. Interstate 95 and Interstate 278. Those roads converge and there is a yield zone. And that accident occurred literally underneath the sign that says Westchester Avenue. The
Yeah, that's
subject
not over there where people are coming off of the George Washington Bridge. This is much further north than the George Washington Bridge.
Yes, yes,
Okay, got it. Thank you.
yes.
Okay,
Now, and
thank
just
you.
as far as if I may make one last point about there's some conversation about a truck being observed from Mr. LeBron. Mr. Biggs, who was in the accident with the Sosa van and the Santiago van, that was a 3-car accident. That was approximately 250 feet away from our accident. That Mr. Biggs said as he approached that accident, there was also a truck there. That is not our truck. That is a truck. That is a different truck. Our truck was 250 feet away. So, you know, as the testimony emerged, people use terms very loosely.
Didn't someone look at the picture and identify your truck? Mark the sign that your truck was within the view. Okay, I'll check the record. Anyway, okay, thank you.
Thank you.
I think all of the appellants have addressed the court. We'll move on to Mr. Platt. I'm sorry.
Mr. Sosa's as well.
Yes, but the attorney is Mr.
Christopher Delacarpini for the estate of Ms. Sosa, Your Honor.
Yes.
May it please the court, thank you very much. As Your Honors have indicated, there are issues of fact in this case that alone support affirming Justice Danziger's decision. I would urge this court, though, to go further and recognize that the city did not even make a prima facie defense in this case here. I think the city's strongest argument on appeal is that its snow removal efforts were reasonable. And I say that because it's the only issue on which the city put in any evidence. The only evidence they had on their snow removal efforts was 3 affidavits from 3 drivers of salt spreaders. There was Mr. Bianco and DiNapoli and Mr. Molina. Mr. Bianco and Mr. DiNapoli, they both knocked off at 4:30 the afternoon before this accident. The snow went on till 1 a.m. Mr. Molina at least was put forward as someone who did snow removal efforts the morning of the accident, the hours before the collision, but he doesn't remember doing it. All he did in his affidavit was read the city's records. And what he basically says is, well, the records say that I drove 42 miles that day, so if I did my route like I should have, I probably hit this stretch of roadway 2 or 3 times. That's speculation. He has to assume the one thing that matters. Did he do the route he was supposed to do? He doesn't know, and the city records don't indicate it. Furthermore, as Your Honors mentioned, there's evidence that the city did not undertake those snow removal efforts that they should have. That's the testimony of Mr. Wright, the expert, and also Mr. Belizzi. But furthermore, the city also doesn't put forth any evidence as to whether those efforts by Mr. Molina, if you can take that evidence, were actually reasonable. The city doesn't have Mr. Molina affirm that, yes, these efforts would have been reasonable under the circumstances. They don't have an affidavit from a supervisor to say, yes, 2 to 3 times would have been sufficient. They don't have an expert of their own. The city neither proved what it did in snow removal or whether that would have been sufficient, what it should have done. I'd like to address, I'm sorry, Judge Rez, you have a question?
No, I wasn't sure if you were done.
I would like to address the issue of notice. The city put in no evidence that it lacked either actual or constructive notice, and there's clear documentary evidence that the city did have constructive notice. There is a teletype, it's in the record at pages 5604 to 05, where the city is actually, DOS is telling its supervisors about this specific roadway as one of 180 throughout the 5 boroughs that are locations known to present problems when we have near freezing or freezing temperatures, and instructs the district supervisors to undertake immediate and then periodic inspections of these roadways. You couldn't have clearer evidence of actual notice of a recurring condition. That's constructive notice.
Thank you, counsel.
Thank you, Your Honor.
Ms. Welch?
Yes, I represent Pedro Sosa, who was so grievously injured as a result of these events. I would briefly like to address the individual appellant's assertion that their negligence, if any, merely furnished the occasion for Mr. Sosa's injuries. There is clearly no agreement as to the relevant facts here regarding either their negligence or where they were parked afterwards, and on and on and on. But there is clear evidence from Mitchell LeBron, whose Toyota was the car that struck Mr. Sosa and his sister and propelled them over the Jersey barrier. Mr. LeBron was very clear that when he came over the rise and descended into the accident area, he saw the vehicles belonging to Mr. Hernandez, Cabral, Cabrera, and Ms. Suarez stopped in the road in front of him. And in order to avoid them, and he says this very specifically, he jams on his brakes, which causes his car to then skid all the way across the roadway to the other side of the CBE, where plaintiff and the Biggs vehicle and the vehicles have already collided. And his car, as it is spinning around 180 degrees, contacts both the plaintiff and the decedent and propels them over the off of the highway. Now, that is that is clear evidence that the actions or inactions of the individual appellants were a cause and not a cause of the injuries here, and did not merely furnish the occasion for them. And if the court looks at the Court of Appeals cases in McMorrow versus Trimper in particular, which is discussed in our brief, and in Tutrani versus County of Suffolk, I would suggest that those cases, especially McMorrow v. Trimper, which is very, very similar on its facts, absolutely preclude judgment for the individual appellants.
Thank you.
And I would,
Wallace, you have 1 minute.
Thank you, Your Honor. Just to point out at first what my adversary says about how we didn't put forth a prima facie defense. Mr. Molina, who was the worker who was engaged in snow removal at the time of the accident, during that time period, did remember specifically the day. That's in his affidavit, which is in and around page 2681. He just didn't remember how many times he did the route. And that, I think, is reasonable when you're doing snow removal on a looped roadway. He was able to interpret the records, interpretation of records, and records show prima facie cases in this type of case all the time. And as to constructive notice, counsel points out there were 180 roadways in the city, 6,000 miles of roadways where the city believed the same problem existed, which is that it was a high area. We were just being cautious on all of them. We know in general that ice happens more often, more frequently earlier on that type of roadway. But that didn't mean that this specific roadway we had notice of that there was going to be such an icy condition on this roadway at this time.
Your Honor, may I make a few comments on this appeal? I'm a respondent on both appeals, actually.
You only reserved 5 minutes, and I gave you the opportunity to have all those 5 minutes.
I reserved 10, but I was
No,
given
I gave
5.
you. It's what I
Yes.
give. Yeah,
Right.
Okay. We're on to Ms. Krachanka.
Yes, I would just like to point out to the court that the photographs depicting the first accident vehicles beneath the Westchester exit sign and even past it are located in pages 2630 and 2631 of the record, and also on page 6174. And defendant LeBron actually expressly testified, looking at the photograph on page 6174, which is essentially the same as the other ones, that yes, he saw that exit side was farther ahead from him, way farther down the road, and that his vehicle is not visible there, even though you can see a big chunk of the road. So that clearly undermines any implication that what he saw and that he crested the van or the truck or whatever vehicle he saw was one of the vehicles from the first accident, and it supports the defendant's view that actually the first accident was significantly farther up ahead.
Thank you, Ms. Soto.
Yes, Your Honor. I concur with prior counsel and what she said, because that is absolutely correct. And further, the accident at issue involved two vans and Mr. Biggs' vehicle. So those are larger vehicles that sat at the crest. So the idea that he could see another 250 feet away, and that's what caused him to go to the left. There were only two lanes. He was in the right, and the left lane is where that accident at issue occurred. So it is quite interesting that he would say he could see that, and that's what caused the accident. And I would also add one additional argument regarding the McMorrow case and the Didarian case that plaintiff cites. I think they're misplaced here. Those cases are precipitated on the idea that there was a duty, and that duty existed because they created the condition. Here, we did not create the condition. We were not the accident in which Mr. Biggs was involved and Mr. LeBron was subsequently involved in. So we did not create the condition.
Thank you. Thank you all, attorneys. Thank you very much.
Thank you.
This was the last argument, and that concludes oral arguments for today. Thank you very much.